All right, we are on the record. We have motions. I think the primary one we're going to deal with this morning is the reinstatement of the third-degree murder charge. And so who would like to speak to that issue first?
Good morning, Your Honor. Mr. Cattell will be addressing the court on that matter.
All right, let me give my understanding where we're at. I had denied the motion to reinstate, saying that the Noor case was not precedential at that time, and that was the sole reason for the denial of the motion. That was appealed to the Court of Appeals, which said no, it had immediate precedential value. Judgment had not been entered yet. Petition for review is taken by the defendant. The Supreme Court has denied review, remanded it back to the Court of Appeals, who then entered judgment. So judgment has been entered on the appeal in this case, so I think we can address the merits. So Mr. Catchall, if you would.
Thank you, Judge Cahill. May it please the court, we really appreciate the opportunity to be here. And you've already said in your last order, you said, quote, if Noor is precedential, this court would now be duty-bound to follow it and grant the state's motion to reinstate murder in the third-degree charge. And that's what we're asking for at this point. Mr. Nelson made two arguments before you to argue against that. One was that Noor wasn't precedential, and the second was that there were some differences in the facts. Any other arguments about prejudice we think are well forfeited at this point. Our initial motion to amend the complaint had pages 8 to 10 were all about how there wouldn't be any prejudice, and Mr. Nelson chose not to contest any of that. So really, I think it's a very straightforward decision. State versus Bloom and other cases from the Minnesota Supreme Court say that this court is relatively free to permit amendments to charge additional offenses until jeopardy is attached, until the jury is sworn. And, that's obviously not happened here. And so we think you have the absolute discretion to add this charge, and we think you should. It reflects the gravity of the offenses.
I do believe the Court of Appeals did, however, remand it for the defense to bring on any other grounds they think I could use to deny it. So, Mr. Nelson, I'm going to actually ask that you be at the lectern.
Your Honor, is there, I don't know, is there a way I can turn this monitor off or something? Because this is all very distracting, and I'm sorry.
I think you can just turn it down a bit.
This one?
Don't close it, but...
Is that okay?
Does that work?
Okay. Yes, Your Honor, I believe that there are three bases under which the court could deny the state's motion. First and foremost, what I would note is that this case is both procedurally and factually different. Ultimately, what the Court of Appeals said in the opinion for this case, in Chauvin, is that if it's precedential, it has to be applied consistently to procedurally and factually similar cases. So there's a question of the distinguishment between Noor and that line of cases and the facts of this particular case. That's one ground, and I can address that in a second. The second is that I'm raising the question, and we raised it in our response at the Court of Appeals, of the ex post facto application of Noor. Third, Your Honor, under Baxter, this court just has the housekeeping ability to deny. So, addressing the first issue first, we have to remember that Noor, what Chauvin says is that Noor is precedential, but there is still the Fabio versus Bellamo case, which says that once the Supreme Court grants review of a case, it limits the precedential value. Fabio versus Bellamo says once the Supreme Court has granted the petition for further review, that case is of minimal precedential value. So you have that to start with. So the question is this case factually or procedurally different than the Noor case? And they're completely different. What we've seen in these lines of third-degree murder cases is really two lines that have come. You've got the Knorr, the Middich, and the Hall cases, which are all cases that look at whether there was sufficiency of the evidence from a post-conviction standpoint. That's one line of cases. You have a second line of cases, the Zumberge, Lineweber, Hansen, that whole line of cases that look at and analyze whether third degree is appropriate as a lesser included, right? And so you have these two lines of cases. Ultimately, looking at the Knorr line of cases, where there's a conviction, it's a much different standard than the appeal or than the lesser included standard.
But Mr. Nelson, aren't I pretty much restricted? The Court of Appeals specifically remanded to this court with instructions that I make a decision consistent with their opinion.
Say in the Chauvin decision that you are bound to, or you are permitted to review other issues, right? And the question is, and what Chauvin says is, if it's precedential, right? It's precedential. That question has been answered at this point. Is it factually or procedurally similar?
Okay.
Right?
Go ahead.
And so under Knorr, if you look at the facts of Knorr, it's a Minneapolis police officer. This is a case involving a former Minneapolis police officer. And that's about where the similarities end. And if you look at the line of cases, Knorr, Middich, Hall, all three of those cases, there's some sort of an instrumentality that is used, a gun or a car, generally speaking. Those items could be viewed as inherently dangerous. So in Knorr, right, they're saying, what I understand Knorr to stand for is the single person rule, and whether a single person can be the focus of the third degree murder. But in the Knorr case, Mr. Knorr shot his gun across his partner's chest towards a silhouette that could have been anyone or anything. They just saw this biker. Anybody within the line of travel of that bullet was put at risk. It happened to be a single person that was there. And I think that that's significantly different factually from what is alleged in this particular case. They are alleging that my client did not do something inherently dangerous. It was focused on a single person. So factually, these cases are considerably different. Ultimately, they're very different procedurally as well. Because again, Knorr, Middich, Hall, those were all post-conviction appeals to look at the sufficiency of the evidence. Procedurally, we are pre-trial. This is a motion to amend the complaint. And it's similar, it's a similar standard, the abuse of discretion standard for this court, to determine whether a lesser included should be added, right? So we're procedurally more consistent in the Zumberge line of cases, right? So that's number one. Then we have the ex post facto. Sorry.
I think they are different, nor in this case. I said so in the original probable cause order. Said we could understand how Noor falls under third-degree murder because firing a gun out the window endangered not just the person who was killed, but also that officer's partner, biker who was going past at the same time. And so that was clearly fit in the universe of depraved mind, danger to others, plural.
Right.
And I think the distinction we made in the original probable cause order last fall was this is a different case. It is more focused on a single person. And clearly I said the single person rule applies or doesn't apply depending on how you state the rule. And basically there has to be more than one person endangered by the conduct. The Court of Appeals in Norris said they did not take the route of saying we don't have to reach the single person rule because it did endanger others, not just the victim who was shot. They didn't take that route. I think they didn't have to, but they didn't. They said single person rule. When the animus is directed at a single person, that's enough. It falls within the gambit of a third-degree murder charge. So I agree they are different cases, but it seems, if anything, this is more the single person rule application, even more than Noor, And I'm not sure why they felt the need to decide it that way, but I'm not questioning the Court of Appeals.
Well, I
This
mean,
time.
and that ultimately what the Court of Appeals reversed on in this particular case was a very narrow, very, very narrow inquiry, which was simply the question of the precedential nature of their opinion and whether you were duty-bound to follow it. But again, you are still able to analyze the case from the facts, right? Because that's what the Chauvin case says. The Chauvin case, the Chauvin Court of Appeals decision, specifically says that you're duty-bound to apply precedent provided it is a factually similar case, right? And that's, so inherent in that is your discretion to say, this is not a factually similar case. This is a distinguishable case. Whether you apply the one person or the single person rule, it's immaterial, is factually significantly different. And so that wouldn't apply. But if you go back over then and look at that other line of cases, the Zumberge line of cases, and you look at what are the differences between these two types of lines of cases. Well, again, in Knorr, it was a gun. It's inherently dangerous. In Middich, it was a gun. In Hall, it was a car being driven recklessly into some person or into any random other car. In all of the other cases, it's really much more of a focus on, it was obviously the defendants seeking a lesser included, but they distinguish, they're able to factually distinguish. Even though there was a gun, you pull up a gun and you shoot it at a crowd. They're all instrumentalities. Factually, there is no instrumentality here other than arguably Mr. Chauvin's knee, which is not inherently dangerous, right? So that's, I think, the main factual distinction, and what gives this court, what the Chauvin opinion says, you're not duty-bound to follow it if it's factually distinguishable. So that's the sum total of that argument, and I'm happy to. So the second issue is this concept of ex post facto, right? And ex post facto under Weaver versus Graham, an ex post facto law is something that criminalizes conduct that would not have fallen under the law when it was committed. It increases the burden of punishment for a crime after its commission. It deprives one charge of a crime of a defense that was available when it was committed, right? So if you apply those standards and you look at, we've got 50 years of precedent, arguably 100 years of precedent, right? That says this single person would be a defense, right? And it was a defense. It was such a defense that the court dismissed it for probable cause. Knorr comes along and says, hey, we're changing this rule.
And just so we're clear on your ex post facto argument, the statute murder in the third degree, as it exists now, and as the state is attempting to add, the language has not been changed since May 25th, 2020, when this incident happened. Would you agree with that?
I would, but case law can, under federal law at least, case law can also be the basis for an ex post facto.
Okay.
That is Stevens versus Thomas, as an example, Stevens versus Thomas, 19 Federal 3rd, 498, 10th Circuit, 1994. So under federal law, an interpretation or a novel interpretation of case law can create an ex post facto challenge. And then finally, Your Honor, the last thing is simply under Baxter, right? Baxter was a case that I'm familiar with. Baxter, we show up for the day of trial, right? I mean, we're literally now, in this case, we're in the middle of selecting a jury. We show up in Baxter for the day of trial, and they file a motion to amend the complaint, right? And the court denied that. It got appealed. And in Baxter, they specifically say that even though the state has the ability and has great discretion to amend the complaint, the court retains its inherent authority and its inherent discretion. And so even under Baxter, you still have the ability to deny this motion.
All right. Mr. Catchall, I'd like you to address, if you could, both the ex post facto and the inherent judicial authority arguments.
Sure. I think first it's just important to note that my friend on the other side isn't really making a prejudice argument, which is consistent with his briefing before. That's the typical reason why a motion to amend would be denied, and I don't think it's available here. And so we're left with the arguments that he's made. With respect to ex post facto, I think there are several problems with that. I mean, first of all, the ex post facto clause can only be violated by the legislature, and to the extent so, given that, as you were saying, Your Honor, there's already a third-degree murder statute, it would require a complete, unpredictable departure from law. And this is the opposite of that. I mean, this one-person rule goes back 100 years to 1896, and most importantly, there was an on-point, unpublished Court of Appeals opinion in the Patton case in 2000, which does exactly what, the legal theory that we've embraced here, that Knorr has embraced, and the like.
Would you at least agree that it was being discussed a lot and it was a bit murky?
Your Honor, I don't know that we would agree with that. I think, for reasons that are briefed to the Court of Appeals explained, I think those cases are about actually intent to kill, not one person versus many. We understand you had a different view of that, but I don't think that we would say that it's murky. But even if it were murky, that's not an ex post facto violation. I mean, the idea that Officer Chauvin would have been surprised by it, act in reliance on existing law or something, would be pretty ludicrous. I mean, this has been, even if you think there was any doubt in Minnesota, it has been the law in many, many places, and the Lefebvre Treatise makes this very clear. But I certainly don't think that it's an ex post facto violation to apply something. Indeed, that would make the 2000 Court of Appeals decision also an ex post facto.
All right.
You had also said right at the end of when I was speaking the first time that you had understood the Court of Appeals to permit you to examine new arguments. And I think, with respect, I think that overreads what the Court of Appeals said. I don't think that they repudiated the traditional forfeiture rule, which is, quote, the well-settled rule that a defendant is not entitled to raise issues already decided on appeal or which are known and not raised on the first appeal. That's State versus Andren from the Supreme Court. I think what the Court of Appeals was saying was, look, if there's good cause for some new argument that hasn't been made, okay, fine. I don't think that anything today rises to that level. So the first thing that my friend on the other side said is that Knorr was factually distinguishable. And as I was saying before, I think you've already rejected that argument at page 3 of its order. But just on the merits, I think, major points for creativity to Mr. Nelson, but this theory is nowhere in Knorr, and I think that was what your question to him was getting at. I mean, at page 4 of the Knorr opinion, the court said that Knorr argues the conviction under 195A can't be sustained if the alleged conduct was directed at a particular person. Knorr contends the evidence showing his death-causing act was directed at a person who appeared outside the squad car, and he can't be convicted of third-degree murder. The court didn't say anything like, oh, he endangered many people. Instead, at page 7, the holding is, quote, we therefore hold a conviction for third-degree murder under 195A may be sustained even if the death-causing act was directed at a single person. There's nothing in the legal analysis in Knorr that mentions that the cop put anyone else in danger. Indeed, that language about the silhouette that Mr. Nelson is referring to wasn't even language by Mr. Knorr, it was language by Mr. Knorr's partner. And even the dissent by Judge Johnson agreed with those facts. And so that's why we think this case is just like the cases in the Lefebvre Treatise that Knorr favorably cited, playing Russian roulette with one person, shaking an infant, throwing a beer at someone carrying an oil lamp, or, it's an unusual fact pattern, but all of those are examples of a depraved heart. And, more than a century of precedent, as I said, since the Lowe case in 1896 says that, it isn't necessary that more than one person was or might have been put in jeopardy. That's this case. My friend made some points. He said that it was procedurally different. And again, I think your order at page 3 rejected those arguments. And I think that the only way he gets there is by quoting 2 sentences from Noor, but not what comes next at page 6. And I'm happy to walk you through it, but I think page 6, I think, answers that claim. And with respect to cases like Middich and the other cases that he cited, Zumberg, all of those are cases that I think are very clear. Middich says that they affirmed the third-degree murder charge, even though the defendant's shots, quote, were directed with particularity at the victim, at a single person, and that's how later cases like State versus Wahlberg characterize it. To the extent there's any doubt in your mind, we'd be happy to brief this and go through the facts of those cases, but we don't think it's necessary. We think, at the end of the day, this is very much like State versus Nelson, or it's an even easier case than State versus Nelson. There, on the very day of trial, there was an amendment that was granted to add kidnapping charges when there was already a sexual offense charge, and that's two distinct offenses. Here, the difference between third-degree murder and second-degree manslaughter is very much one of degree. It's just about how depraved and dangerous the defendant was. And the defendant's answer to both charges is the same. He's saying, I acted properly. And if the Court of Appeals in Nelson versus State allowed the adding of kidnapping to a sexual offense claim, we think that this is far, far easier. My friend talks about Baxter, but I think he misses 2 things about it. First is, it was a Court of Appeals decision, and the Court of Appeals was just reviewing the district court for an abuse of discretion. The court was just saying it's permissible to deny an amendment on the morning of trial, not that it had to. And that just is a second point. You couldn't have more different facts. The defendant there had made a speedy trial demand, unlike here. The state waited until the morning of the trial to amend the complaint. They waited to interview the witness for 1 month, and the delay there was extreme. And through, the Baxter decision says it's about timing. It's about the fact that this was really done at the last minute when the state had opportunity after opportunity to do so. Here, we've moved with dispatch, in order to bring this to you.
You wish to be heard again? All right. With regard to the state's motion to reinstate, the court is going to grant the motion to reinstate, and I want to go a little bit at length addressing it. In reading, obviously, the Noor opinion came out, and it was very clear that I disagreed with it, said so, denied the motion initially because of my disagreement, but not without first checking to see if I was duty-bound to follow it as precedent. And now, based on the defendant's appeal, this Court of Appeals has made it very clear, yes, I was bound from the moment the opinion was filed, and I accept that. I even agree with the decision in State versus Chauvin that their opinions have precedential value immediately. And I want to explain why, because I did not believe so before. My concern is how the Court of Appeals got to that position. They stated in their analysis that the plain language of the rule says that precedential opinions take immediate effect. That implies that this court disregarded plain language in the rules, or at worst, was too lazy to look up the rules. Neither is the case. Upon reading the Noor opinion, realizing its application to this case, this court immediately turned to the rules to look for plain language as to when opinions that are marked as precedential have in fact that precedential effect. We found silence, not plain language. I think the Court of Appeals reaches too far by saying there's plain language in the rules. There is silence. There is not language prohibiting or saying that it is entered at judgment or that it takes effect immediately, but it is silence. And I think what the Court of Appeals has inferred from the silence is that opinions take immediate effect when filed. I accept that because of my second reason. Despite my disagreement with them that the plain language is there, it is my belief and an analysis that Courts have inherent judicial authority to say when their opinions have effect. If the Court of Appeals believes that their precedential opinions, they get to decide when they're going to file it, how they're going to file it, whether it's an order opinion or more extensive. That is in the rules. There is plain language about that. But clearly every court has inherent judicial authority to decide when their opinions will be effective. Because the rules were silent, in this court's view, our next step is to look for case law. And we found Collins, which said it does not have precedential value until judgment is entered. The state has successfully argued to the Court of Appeals that that was dictum in Collins and did not establish the principle that the opinions take precedential effect immediately. And I accept that. That is their ruling. And based on that, I think the inherent judicial authority, there is that authority to make that decision and to say, when we file a precedential opinion, it has immediate effect. I accept that now as a rule of law promulgated by the Court of Appeals due to its inherent judicial authority to make such pronouncements. Because no pronouncement was made to such effect by any court that I was able to find before the Chauvin opinion was filed, that is why I said that the precedential value did not attach until judgment, because that's what Collins said. District courts, I think, are more at risk to start calling Supreme Court pronouncements dictum and refusing to follow it because of that. I am granting the motion because although these cases are factually different, that is Noor and the case before us, I don't think it's a factual difference that weighs in favor of denying the motion to reinstate because of the language of Noor. Noor is very clear. When intent is directed at a single person, this is a legal principle that they've established now as precedent, then third degree may apply. Single acts directed at a single person fall within the gambit of murder in the third degree. And as I said, that was part of their holding. It is not dictum. Accordingly, I am bound by that. I have to apply the rule. Even though they are factually different, I have to follow the rule that the Court of Appeals has put in place, specifically that murder in the third degree applies even if the person's intent and acts are directed at a single person. I disagree with the state that the defense has forfeited any other grounds, and so that's why I'm permitting the other grounds to be argued, but I did not find them availing here. First of all, the ex post facto, the statute has not changed. It has remained the same for years, was the same as it is today as it was on May 25th of 2020. And finally, discretion. It is an abuse of discretion standard, but discretion can be abused. And I think when my ruling, both in the fall and lately, in denying the motion to reinstate, was based on a legal principle alone, not on the facts of the case. It was the facts of the case that this appeared to be an act directed towards a single person, and on that legal principle of the single person rule, this court granted a motion to dismiss for probable cause, denied the motion to reinstate, but now that the Court of Appeals has said in a precedential opinion, specifying the single person rule applies to third degree murder, I feel bound by that, and I feel it would be an abuse of discretion not to grant the motion. As a last comment, there are cases, in fact I have myself, I think it was trial before last, on a criminal sexual conduct case. The state came in on the day of trial asking to add an assault in the first degree charge, and it came out of left field. There was really no notice that that was going to be important, and since it was an assault in a criminal sexual conduct case, we were talking about different intents, different foci on the acts that were committed. And I denied the motion to amend because I thought it came out of left field, basically. And this case is different. This charge has not come out of left field. It was originally charged. I think the defense has been aware that the state will take every opportunity to try and add it back. The remedy is not to deny the motion to reinstate based on timeliness. It is to grant a motion for continuance if the defense can prove to me they are prejudiced by this ruling. So, murder in the third degree is reinstated as originally charged. In this case, this is not a decision as to the other 3 defendants who are set for trial on a later date, and we'll address that later. Mr. Nelson, anything? Are you ready to proceed?
I'm ready to proceed.
All right. No other requests? All right, we'll then proceed. We're going to take a 10-minute break. Do we have other motions in limine you wish to address today, or should we?
Yeah, I think we can. If I can just make a brief record on the motions. It's just a kind of a scheduling plan.
Sure.
So, Your Honor, I spoke with Mr. Frank last night, and I think we're both in agreement that there is state's motion number 2 and number 6 remaining, and 4 defense motions remaining. 3 of the total motions are dealing with expert testimony and things of that nature. So we were proposing that what we would do, as we discussed yesterday, would be to put together a flash drive with all of the expert reports for the court to review in camera and keep under seal, that you would have over the weekend to review those reports so that when we're making these arguments, it's not
in a vacuum.
Not in a vacuum, exactly. And then we'd like to, so we'd give you over the weekend, we're granting you the weekend, Your Honor, to review these reports, but address those issues on Monday.
And that makes perfect sense.
Yep.
So I think we'll address those on Monday.
Yep. And then there's one of the other remaining motions we would also ask to put on Monday, and that has to do with the continued request regarding the previous arrest of Mr. Floyd. I know that we have to supplement that. We will also prepare a flash drive for the court to turn in with all of the documents pertaining to that for you to review, so that, again, when we're talking about this, it would not be in a vacuum.
Well, and I think for the Spriegel motion that we handled back in September, I did review most of that, including the body cams.
So one point on that is, I believe that that motion was made in one of the co-defendants' case, and we may have joined in on it. So I just want to make sure that there is a record in this case.
Oh, and I'm not saying that you waived it or anything.
Yeah,
It's been decided.
So but there is also additional information that I think has come to light subsequent to that decision that the court should be aware of.
Does that schedule work for the state, Mr. Frank?
Yes, Your Honor, and I think what we're asking the court to do is to receive those items not as exhibits offered at a hearing or anything of that nature, but truly as a matter for in-camera review to inform the court about the issues to be raised publicly in the motions, but to have that background available, and would ask the court, if necessary, to make the findings that in-camera review is appropriate for that, because there has been no determination made yet about admissibility of anything in those reports. And that really not just the expert matters, but the other 404B incident as well regarding that.
I think it's all appropriate, and so I'm going to receive them for in-camera review. They are not going to be filed with the court and thus not available publicly. So let's proceed on that basis with Monday with those 2 issues, the experts and the May 16th.
And that leaves 2 remaining issues, I think, one of which we can get rid of, I think, right now.
Okay.
And that is the state's, or excuse me, the defense motion number 36, relevant to Your Honor, what the motion was, and I can just simply say it was, we have made a motion to restrain or to prohibit the state from referencing civilian complaints regarding Mr. Chauvin. The state essentially agrees with us in their reply, with the exception of the 404B material that you've already offered. They just wanted that point of clarification. I think that's clarified. we're not,
Anything that I've ruled admissible under 404B in our prior order is obviously admissible. The ruling for other complaints.
Right, you're right. I think our response was intended to seek this clarification, that this motion is only about personnel matters, not the 404B incidents we had proposed to the court and the court had already ruled on.
Right. And for example, the personnel decisions that might have been made, again, and any findings that were made aren't really admissible. It's about the facts themselves of the incident.
That is true.
Okay. And that is certainly admissible based on the court's ruling.
right.
Okay, I think we're all on the same page.
Yeah, simply, there's no reference to any civilian
Right.
complaints, it's personnel issues. That was the point.
What I take the defense motion as is you will, or you don't want the state to say, well, are you aware that Mr. Chauvin had X complaints before the state?
Right.
Is that correct?
Correct, Your Honor. And the results of any of those, we are.
Right. All right, I think we're on the
Okay.
same page.
Yeah, so then, so for purposes of, again, scheduling tomorrow, being Friday, I don't know that we will need this. It leaves only issue number 6 of the state, which is some training materials, but I think that we had kind of agreed to reserve those because we're working on which materials are coming in.
Right.
So tomorrow,
We don't have to be here at 8 a.m.?
it'd be nice, unless you are.
I've been working you guys pretty hard, so I agree. Let's start it. And the jurors are getting in. We have a nice rhythm with them on getting here by 8:30, seeing the orientation video and everything else. So I'm not going to bring them in earlier. The court schedule was not to have an 8 a.m. start. It was only to accommodate the motions and eliminate. So we'll start at 9 o'clock tomorrow.
Thank you, Judge.
Your Honor,
Mr. Framer.
the state would like to make a record about the trial proceedings over the last couple of days, given the pendency of several levels of appellate review. And I don't know if the court would like to do that after the recess. We have
Oh, you can go ahead and make it now.
What we're asking the court to do, Your Honor, because of the pendency of the appeals and what seemed like technical matters that lead to really problematic potential appeal issues later about the court's jurisdiction, we proceeded with some uncertainty, I think is a good way to summarize it. Uncertainty that we have always feared, and I hope we expressed correctly to the court early on, that jurisdiction of the court can be raised at any time, which means it could be raised in an appeal a year from now, and it's something that can't be waived. And because jurisdiction goes to the power of the court to adjudicate, to do its functions. So we have proceeded with some decisions in jury selection and motions that there is some dispute, as you know, about whether the court had authority to do that while those appeals were pending. Because maybe murky, we can borrow the court's earlier word, because it is somewhat murky about that. What we would be asking the court to do is to make a record essentially ratifying the decisions the court has made, now that we know for certain the court has authority to do that. So the court has, the court has made some rulings about motions in limine, but more importantly has made decisions about qualifications of jurors. And so we are asking two things. We're asking, first of all, for Mr. Nelson and his client to waive any challenge that he would have to the qualifications, the decisions the court has made, the qualifications and seating of those jurors, and also to have the court make a record that the court would not have done anything differently had this appellate issue been resolved Monday morning instead of yesterday evening, and that all the jurors seated, the court still agrees, are qualified based on the voir dire conducted by the parties and the decisions made by the court. That's the approach we're asking the court to do to really shore up this potential future issue.
Refresh my memory, though. The appeal, the latest, not the appeal of the reinstatement, but the appeal / writ of prohibition request that you made this week to the Court of Appeals was tell the district court to stop because we have concerns about jurisdiction. And their response was, based on subsequent events, your motion is now moot. They did not say, am I correct? It's moot, and oh, by the way, start over because there was no jurisdiction for what you did before we filed this order.
That is true.
Okay.
I just wanted to make that clear that I read the order appropriately. I think there's an inference there, although I'm much more happy with plain language than inference. But I think there is an inference there that that the Court of Appeals agreed that there was jurisdiction because we did avoid the third-degree murder issue completely. I didn't even entertain argument or hearing. But we did go forward with jury selection. So, Mr. Nelson, what record would you like to make?
Your Honor, I would just simply note that at the time, we were not making a jurisdictional challenge. I thought that the court had jurisdiction as to the second degree and the manslaughter charges, and that the only question that lacked jurisdiction was the question of the third degree murder. So the Court of Appeals and the Supreme Court have spoken, and I don't think there's any lack of clarity on that issue at this point. So I concur. We've proceeded on, I believe that the court had jurisdiction over two charges. It's no jurisdictional challenge other than on the third degree, which again is now resolved. So I, on behalf of my client, am confident in the decisions that this court has made thus far, both as to motions in limine as well as qualifications of jurors. I'm not seeking to restart the process.
Before we began on Monday, I think I even made the specific finding that I believe I have jurisdiction for everything outside of the third-degree murder, despite the state's arguments that it might affect other parts of the case. So I think we've made a sufficient record as far as that goes, but I'll make one more record. Lest the Court of Appeals thinks that I am intensely incorrigible, I did agree with some of their analysis in this case. And I ultimately did agree with their final ruling because of, I believe they have the inherent judicial authority to do so. But even if I had not agreed with any part of the analysis or did not believe or totally disagreed with their result, I acknowledge that it was a precedential opinion and law of the case, and I would have been duty-bound to follow it regardless of any misgivings that I have about the analysis. And like I said, I agree with their result, just not how they got there. And I'm not that incorrigible that I would completely ignore the Court of Appeals and their pronouncements. That being said, I think we're good until Monday as far as motions. Okay, I'm gonna let's do a break until 5 minutes too. So 8:55, we'll see if we have the next juror and we'll proceed. Okay, apparently Mr. Schaefer says we do. All right, we're in recess until 8:55. Yeah, let's do it later. Morning, sir. Come on up. And you are juror number
31.
31. Right. Before I turn questioning over to the attorneys, I'm going to swear you in so that all your answers are under oath, and then ask a few questions myself.
Sure.
So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
Thank you. We are sticking to COVID-19 procedures. I will keep my mask on. We have plexiglass between us, and there's plexi between you and the lawyers. But that, I think, is sufficient that if you want to remove your mask in order to answer questions, and if it's necessary to be clear, feel free to do so.
Thank you.
But I'll pretty much leave it to your discretion. So, first of all, with regard to the questionnaire, is everything true on the questionnaire? To the best of your recollection?
At the time it was completed, yes.
Yes, and there's actually an issue there that I'm going to talk about. Now, in fact, let's talk about it right now. Your mother was in hospice at the time the questionnaire was filled out.
She was.
Okay. Current status?
She passed away a month ago.
Okay. Do you think that that's going to be, obviously, you're probably still grieving? Is that going to be a problem of being a juror in this case?
That won't be a problem.
Okay. And we'll talk about other issues as well. Other than that, are there any other changes, amendments, additions to the questionnaire?
Yes.
Okay. And if you could state what those are that you recall right now.
At the time the questionnaire was filled out, it was accurate. Since then, I have considered some of my answers and learned more information
Okay.
that would change at least one of my answers.
All right. Is it the type of thing that would either reveal sensitive or embarrassing information about yourself or identification information about yourself? In other words, the details are so specific that somebody would be able to do that? Or is it simply some opinion or other thing that you wanted to amend from the questionnaire?
It's other. It's not sensitive information.
Okay. I think then we'll stay on the audio and the record, and you can feel free to state it since we are in individual questioning.
Yes. Well, it might reveal some sensitive information, frankly, Judge.
All right. Is there any objection to going off audio? All right. All right. Then under the rules, under Minnesota Rule 2602, subdivision 4.4, we're going to go to a modified in-camera examination. Specifically, we'll cut the audio. So in other words. All right, we've had an examination of the juror off audio, but on the record. And on that basis, the court has excused the juror for cause. And it's my understanding that the state and the defense have no objection to that. Is that correct?
That is correct.
And Mr. Nelson, do you have any objection to that?
I do not, Your Honor.
All right. We'll proceed to the next juror then, juror number 36. Come on up. All right, good morning.
Good morning.
You are juror number 36.
Yes.
All right. Couple things. We have all the COVID precautions in place. I'm wearing a mask and will continue to do so while you're here. And we have plexiglass between us, and you also have plexiglass between you and the rest of the courtroom. Leading to my option for you of taking off your mask. If it will be easier to hear you that way,
Okay.
and if you're comfortable, but if you're not, keep the mask on.
I'll take it off.
Okay. In either case, if you could make sure you're close to the microphone,
Okay.
that would help us a lot.
All right.
A couple things before I turn it over to the attorneys. First of all, I'm going to swear you in so that we know that all your answers are under oath. So if you
Okay.
could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Now, first of all, you received a questionnaire which you filled out, and thank you for taking the time to do that.
Yeah.
Is there anything, since it was months ago, anything that you wanted to change, amend, add to? And I say that because sometimes you fill out the questionnaire and then you realize on reflection there are items missing, or you've even changed your opinion about things.
No, not
Okay.
really.
The attorneys might specifically talk about questions, and in doing so, if you find that that's really, there is something you want to change, feel free to do so.
Okay.
Nobody gets in trouble in this courtroom for adding or amending to their questionnaire.
Sounds good.
All right, now, that questionnaire also advised you not to read anything in the newspaper or watch any media about this,
Yeah.
and I assume you've done that, but it was months ago. We understand sometimes that inadvertently you might be exposed to information.
Yeah.
That is not seeking it out. See a headline, a friend might talk to you about the case, and since we said don't tell anybody you're a potential juror, you can't really stop them. Anything like that happened that gave you additional information about the case?
No, I've been trying not to see anything about it.
Okay, so nothing about the parties, the procedures,
No.
anything like that? Okay. You did describe what you, up until the time of the questionnaire, knew about the case.
Mm-hmm.
And the question is going to be, can you put anything you've heard outside this courtroom aside and decide the case just on the facts, the evidence, and the law that you receive from the court?
Yes.
Okay. Also, you may have formed opinions about this case or generally. Also fine. Everybody probably has an opinion based on what they've heard or saw or seen.
Yeah.
Can you put your opinions aside and decide the case on the law again and the facts and the evidence?
Yes, I can.
Okay. Any concerns about that?
No.
Okay. You received a long list of witnesses.
Oh, yeah.
recognize anybody on there?
No, I didn't.
Okay, great. Anything about the length of the trial that would cause you problems?
I mean, I don't know yet how lengthy it's going to be.
Okay, we anticipate that after today, you'll know whether you're on the jury or not,
Okay.
and you'll come back March 29th. So you'll be on your own, do whatever you want
Yeah.
until then. And then we anticipate, our best estimate, is that trial will be 4 weeks long.
4 weeks long.
Is that, can you make that work?
I can, yeah.
Okay, great. All right, before I turn over to the attorneys, I'm also going to advise you, this is kind of a formal process. But as you're talking to the attorneys, sometimes we lapse into normal conversational style, which includes talking over each other. And we are taking this down. The court reporter needs for people not to talk at the same time. So
Okay.
if you could kind of keep that in mind. And to be honest, the lawyers and I are the worst offenders on that. And so we have to be reminded. But just so if you could keep that in mind when you're answering questions.
Okay.
All right. Then, Mr. Nelson, you may inquire as to juror number 36.
Good morning, sir.
Good morning.
Thank you for being here today with us.
Mm-hmm.
Here's what I'd like to do, if it's okay with you, is just kind of go through some general questions, get to know you a little bit better, and then ask you some specific questions about how you answered on your questionnaire. Is that okay?
Yep, sounds good.
I'll tell you, I know it's been a long time since you filled this out. You may not remember every word you wrote down, but we have a copy. We've studied it. We're not trying to trick you. Just want to follow up on some stuff.
Okay.
All right. So if you and I were to meet in a social situation, we're having a casual conversation, first time we meet, what are some things you want me to know about you?
Ooh. I don't know. I'm pretty outgoing, family-oriented. I'm a house person. I like sports, soccer.
Soccer.
Yeah.
Okay. Who's your favorite soccer team?
Ooh. It was Real Madrid when Ronaldo was there, but yeah, right now, I still go for Real Madrid, I'd say.
Okay. Great. When you received the notice that you were going to be a juror, just the general notice, you got jury duty, what was your first reaction to that?
I mean, it was kind of mind-blowing because it's a big case. So yeah, it was kind of exciting.
Exciting?
Yeah.
Why would it be exciting?
I mean, just because it's a big case, and yeah, that's about it.
Okay. Did you have any concerns about being called as a juror?
Not really. Didn't thought about it.
Okay. How about when you got down to the government center today?
When I what?
When you got here to the government center and you see, the National Guard and
Yeah.
barricades and all of that, what did you think?
I mean, nothing about it. I mean, it was secure. I didn't feel not safe.
Okay, good. And do you have any concerns about being here during the age of COVID-19?
No, not really.
Okay. So let me ask you, in your, I double check one thing, I'm sorry. In your personal life or your professional life, can you think of a situation where you have ever been called on to resolve a dispute between two people?
Yes.
Okay. Without revealing people or any identifying information, can you just give me a general sense of what
I
that
mean, I used to be a manager, so
Okay.
so yeah, there was a lot of issues with workers and stuff like that.
Okay.
So yeah,
So what types of issues would you be called upon to resolve?
I mean, just dumb stuff like people not liking each other or stuff like that.
So kind of interpersonal disputes?
Mm-hmm.
Is that a yes? I'm sorry, we have to say
Yes.
yes.
Yeah. Sorry.
I don't, I'm trying to preserve the record here, right?
Okay.
So,
Yeah.
I'm not trying to be rude or glib.
No problem.
Okay. So you have two coworkers, right? And they work under you. One of them comes and says, "He did this to me," right?
Yes.
And how do you resolve that conflict? What did you do to try to resolve those conflicts?
Just hear both of them, and from there just come to a resolution.
Okay, but so was it simply just listening to someone and come to how do you arrive at that resolution?
Just common sense, see who's like in the wrong, or
Okay.
you know.
So that kind of leads me to my next question is, how do you determine who's telling the truth in this situation? What do you do for that?
If there was more people, I will call them in and ask about it, because clearly I wasn't around. I could have been in the office. So maybe call more people that was around there, and to see who's telling the truth.
Okay. Would you look for any other type of evidence?
No, I mean, if it was something bigger, I could check cameras or stuff like that.
So you could potentially get additional evidence, right?
Yeah.
And then, correct me if I'm wrong, based on what people say, maybe other witnesses, what they say, what other evidence may exist, like cameras, you can come to a conclusion,
Yes.
right? Can you think of a situation where you would have two people looking at the same circumstance, like you're watching the same TV show almost, right? And they both view it differently? Like they both reach different conclusions?
I mean, it hasn't happened to me, but I think it could happen if the person likes more one of those people involved in the issue. Like, it could happen.
Well, let me put it to you this way. Your job as a juror, right? You are what we call the judge of the facts.
Yes.
Right. Your job is to determine what happened in this particular case, right? And then you're to take those facts and apply it to the law that the judge gives you. Do you understand that? So let me ask you a couple of questions. If the judge tells you this is the law, and this is what you need to decide, and you think it's wrong, you don't agree with it, whether it's a moral disagreement or a personal disagreement, or you just can't believe that that's the law, can you follow the law as the judge tells you to do?
I can.
Okay. Even if you think it's wrong?
If it's wrong, if I think it's wrong,
Right.
I mean, I also follow the law.
Still follow the law.
Yeah, but if I feel that something is wrong, I don't get the question, honestly.
Sure. So, kind of a strange example. But what if let me think of, what if I were to tell you the judge told you that DWI, driving while impaired, is perfectly legal, right? You can drive as much as you want and as drunk as you want, right? You may disagree with that, right?
Yes.
You think it because DWI is wrong. But what if you're sitting in this case, right, and the judge tells you something that you think is wrong, right? Do you understand what I'm saying? Can
Yes.
you still follow the judge's instruction, even if you believe it's wrong?
Yes, I can.
But again, kind of back to the original line of questioning, which was this: you are one of 12 people. Do you understand that?
Yes.
And would you agree with the general principle that there are two sides to every story?
Yes.
Do you think it is important to listen to both sides before you reach a conclusion?
Yes. Of course.
Can you wait for the entire trial to be over before reaching a conclusion?
Yes. I will have to hear every detail about it.
And so then the question becomes, now you're sitting in the jury room and you're deliberating, right?
Yeah.
11 other people, 12 including you. And you see some piece of evidence that comes into this trial, and you think it's the most important piece of evidence in the whole trial.
Okay.
Another juror's looking at that exact same piece of evidence, and he says or she says, oh, that's meaningless, it's irrelevant, that's not important. This is what's important. How do you resolve that type of conflict? What do you do?
I mean, when we are already talking with all the jurors,
Mhm.
I mean, just talk it out, like hear their point of views and my point of. They have to hear my point of views, and yeah, there's gonna be 12 of us, so.
Right. Are you willing to re-examine your own point of view?
Yes.
So if that piece of evidence is sitting in front of you, and you think it's the most critical piece of evidence, that's the key that unlocks this whole story, and someone else says, no, I see it a different way, are you willing to listen to that other person?
I'm willing to listen, and I hope they're willing to listen to my points as well.
Right. That's what we hope for ultimately too,
Mhm.
right? But I guess then the question becomes, what if you continue to persist in the idea that this other juror is wrong, right? That he's wrong, I'm right. How do you handle it then?
How do I handle it? Just talking it out, like I said. I might be wrong.
Okay. Let's say you've talked it out over the course of hours or days, right?
Yeah.
Do you just go, all right, fine, I give up, I'll agree with you, simply to make a decision, or are you willing to stand by your principle even if other people disagree with you?
I'm willing to stand by my principle as well.
And you, again, understand that this case is going to, we're anticipating it's going to last about a month, right?
Yeah.
And I know, based on your answers, that you've seen some videos that have been publicly released about this case.
Yes.
Would you agree that that is one piece of evidence?
Yes.
Can you understand that there is a lot more evidence that we have to discuss?
Yes.
In fact, we're talking about this lasting a month, right?
Yes.
So, despite having seen this video, are you willing to listen to all of the other evidence?
Yes.
And you may have formed some opinions already. In fact, I know you have, based on what you've seen. Are you willing to potentially allow all of that other evidence to change your opinion?
Yes.
So I just want to ask you some follow-ups on your questionnaire, sir.
Okay.
Shouldn't take too long. Again, the questionnaire was filled out a couple months ago. I understand you may not remember everything you read. Again, I'm not trying to trick you. I'm just trying to explore some of your thoughts
Okay.
and why you may have written what you wrote.
Sounds
So,
good.
the first question that you were asked just was basically for you to give kind of an outline of what you knew about the case already, right?
Yes.
And you wrote a fairly long paragraph onto a second page about what you knew and what you remember seeing, right?
Yes.
Now, you wrote, for example, when George Floyd was on the floor, Chauvin was kneeling on his neck the entire time. George Floyd was screaming for help and desperately screaming that he couldn't breathe. All this while the rest of the other officers were just watching it happen, and bystanders who were witnessing were telling Chauvin to get off George's neck because he was killing him. So, would you agree that in your paragraph, part of your paragraph, you chose some words that are indicative of your opinion of this case?
I mean, I just put whatever. I just described the video I saw,
Okay.
pretty much.
But like the word desperately screaming,
Mhm.
right? Desperately, you've formed an opinion about what you saw in that video, that there was desperation. Would you?
And that's what it was.
Okay, and that's fine. And so I want you to acknowledge that you formed an opinion about this case, right?
I mean, like I said, that's what it was. Like, everybody's gonna see him, that he was desperate.
Okay. You agree that you have formed an opinion about the case, right?
If you would say it, then yeah, that's what it is.
So, because the next question kind of asks you about your opinions. The question was, from what you have seen, read, or heard, do you have a general impression of the defendant, Mr. Chauvin? And it gave you some options: negative, very negative, neutral, somewhat positive, or very positive. It was
Yeah.
like a kind of a spectrum of options. And you checked very negative. Right? So you have formed here already a very negative impression of Mr. Chauvin based upon what you saw in that video. You would agree?
Yes.
And it's perfectly fine for you for that to be your opinion. Right? I'm not challenging that.
Yeah.
And the questioner asks you to explain, and you say there was no reason for Chauvin to kneel on his neck for that long, and him just being stubborn, not wanting to let go, gave me the impression of him just showing off his authority. Right?
Yes.
So again, you're acknowledging, and it's okay. I'm really not trying to, say that you can't have an opinion.
Okay.
I need you to acknowledge that you have formed some thoughts about this case.
Okay.
And that those thoughts really go to the ultimate question that a jury has to decide. Is Mr. Chauvin guilty or not guilty? Right?
Okay.
And so if I were to ask you right now what your verdict would be right now, guilty or not guilty, what would it be?
Objection, Your Honor. Sustained.
So you understand, and you were asked some questions about the principles of law that apply. Right? You were asked questions, and the judge reminded you yesterday that there are very important constitutional principles that apply, such as the presumption of innocence. Do you remember that?
Can you repeat the question, please?
Sure. In the questionnaire, and then yesterday when the judge was giving you some instructions,
Yes.
you were told about some important principles of law.
Yes.
One of those principles being the presumption of innocence,
Oh, yeah.
right? So Mr. Chauvin is presumed innocent of these charges.
Yes, until we see all the evidence and everything,
Right.
witnesses.
And so you have formed an opinion about his guilt or not guilt status, correct?
Yes, but like I said, I'm willing to see all the evidence and everything.
Okay, and
Hear witnesses.
that's ultimately the question, right? I mean,
Yes.
is we know you have an opinion,
Mhm.
right? And what you have to do if you were to be selected as a juror in this case is to set everything that you know from before aside.
Yes.
To say, yeah, I don't think very highly of Mr. Chauvin, but I haven't heard all the facts yet, right?
Right.
Can you do that?
I can.
You were asked about the number of times that you have watched some video of Mr. Floyd's death, and you estimated it to be 2 or 3 times. Would that be accurate?
Yeah, I'll probably say like once or twice and maybe some clips about it.
Okay. So that's kind of what I wanted to ask is, when we talk about the video, there was a video that was uploaded to, I believe, Facebook.
Yeah.
It went viral and was shared around
Yes.
the world. Is that the video that you have watched once or twice?
Yes, that's the video.
Okay. That video, did you watch it from start to finish?
Yes, I did.
And so you watched the entire video 2 or 3 times? Or once or twice, I'm sorry.
Yeah.
But you also have seen various news stories, things in the media that may have a still shot from that video, or it may be just 30 seconds of that longer video, right?
Yes.
Okay. And you understand, again, that video is just really a finite number of minutes in a much bigger picture.
Yes.
Are you willing to set any opinions you may have formed watching that video based on all of the other evidence that may be introduced in this case?
Yes.
So you were also on the questionnaire asked some questions about what I've kind of referred to as the aftermath, the protests, the demonstrations, and ultimately the riots
Yes.
in Minneapolis. And you indicated that you felt that the aftermath, so to speak, had a negative impact on this community.
Yes, it did.
And can you just explain a little bit more?
I just feel that it just went bad. Like it wasn't. There was a need for all of the criminal activities that happened, all the burning and looting and all of that.
Okay. Do you think that anything positive came out of it?
I mean, yeah, probably people wanted to voice their opinions, how they felt. Yeah, but then we had all the people going to those events for the wrong reasons.
And you can draw a distinction between a person's voicing their displeasure, protesting, and looting or rioting.
Yes.
There were a series of questions that, and I'm sorry, I don't know if I'm missing a page. If I can have 1 second, Your Honor. I apologize. There was this, thank you. There was a series of questions that you were kind of asked to circle your opinion from 1 to 5. Do you remember? You may not remember what they all say, but
Yeah, I remember doing that, but
yeah. So there were roughly 12 of these statements, and then you were asked to strongly agree, somewhat agree, have no opinion of it, somewhat disagree, and totally disagree or strongly disagree, right? So I want to ask you about a couple of your opinions. One of the questions, or one of the statements that you were asked to rank was, discrimination is not as bad as the media makes it out to be. And you circled that you somewhat disagree with that statement. Can you explain what your thinking was there?
it says that media one. Sorry.
It says discrimination is not as bad as the media makes it out to be. And you somewhat disagreed with that statement.
That's just how I feel about it.
Okay. So you don't think that discrimination is I mean, I'm not suggesting that you don't think it exists or that it happens, but would you, another way of saying this being that you think that the media may embellish discrimination?
I mean, the media, even when the video surface, like all you're gonna see is the picture of him kneeling in George Floyd's neck or stuff like that. The media just puts things a little higher than what they are.
Okay.
What's gonna like bring more attention to them? That's how I feel.
Okay. And so in that regard, you can separate what you may have seen in the media from the evidence in this case.
Yes.
Do you think that to some degree your opinion about this case that you have coming in here today was influenced by the media?
A little bit, yeah, but like I said, I still need to see the bigger picture, evidence,
Okay.
hear witnesses and all of that. There's more to that than just what media shows.
Okay. One of the other questions was, because law enforcement officers have such dangerous jobs, it is not right to second guess decisions they make while on duty. Do you want me to read that to you again?
Yes.
because law enforcement officers have such dangerous jobs, it is not right to second-guess decisions they make while on duty. Okay? And you strongly disagreed with that statement. Okay?
Okay.
Can you explain that?
Why strongly disagree? I didn't understand the question.
Okay. Well, I mean, let's just flesh this out a little bit.
Yeah.
Police officers or policemen make a variety of decisions, agreed?
Agree.
And some of those decisions, they have a lot of time to think about those decisions. They may talk to their colleagues about it, right?
Yes.
And that's not the kind of decisions we're talking about, I think. Right? If an officer breaks the law, you wouldn't question, and they have plenty of time to make that decision, right? You wouldn't question a prosecution of an officer for breaking the law. Agreed?
I would. If they're breaking the law, I would question them.
Right, that's what I think we're agreeing. I'm saying it poorly, unfortunately. Let's assume an officer was stealing drugs from the evidence room. Right? It's a conscious decision. He makes that decision, or she makes that decision. They should be prosecuted, right?
Yes.
Their decisions should be second-guessed, in other words, right?
Yes.
Okay. But would you agree that there's a difference between those types of decisions and an officer is chasing a suspect down, they've been in a car chase, they're chasing this person down a dark alley, there's no lights, and suddenly the person turns, brings their hand up, and the officer shoots, right? Split-second decision, right? It turns out it was a cell phone that the person pointed at the officer. How do you feel they should be reviewed in those types of circumstances?
I mean, just talk with the police how he felt about it and what he saw, if he really feared about his life.
So there's still an analysis that has to go into it,
Yep.
but whether or not it should be prosecuted criminally is a different question. Would you agree with that?
Yes.
Now you have there was a question that asked, have you or anyone close to you had any of the following experiences? And it was victim of a crime, and you wrote, someone stole my car, right?
Yeah.
Can you just tell me, how long ago was that? Where did this happen?
It was like 4 years ago,
Okay.
outside of my house.
All right.
Yeah, I left it running, and
Oh,
for like 5 minutes went outside, and it wasn't there anymore.
let me guess, it was winter?
Yeah, it was winter.
Yeah. So warming up the car, letting
Yeah,
it run.
and it was fast.
Yeah, someone came in and took it.
Yeah,
Did you call the police?
I did.
Okay. Did they respond?
They did. I think they got in a little chase with them. They crashed the car, unfortunately.
Okay. So the police responded to your request for help,
Yes.
right? Ultimately located the car. The person who stole it gave chase, crashed the car.
Yes.
And what was your level of satisfaction with the police response to that?
It was good.
Right. You were grateful for that?
Yes.
And do you feel that they treated you fairly?
Yes.
Okay. Was the person who stole your car, to your knowledge, prosecuted for stealing your car? Meaning, were they?
No, I don't even know, to be honest.
Okay. So you never had to go to court and testify?
Yeah, I never. After that, I never heard about it.
Okay. Nobody even called you and said?
They just called me to say where my car was and to pick it up, and that was it.
Okay. Did you have to have it repaired through your insurance company, or was it kind of totaled?
It wasn't a bad crash. They just hit him from behind. I don't know. It was just a bumper. So
Okay.
it was an easy fix.
Okay. But no one ever called and said, hey, we can, if you want to make a claim for restitution from this guy or anything like that?
No.
Just got your car back and, right?
Yeah.
Okay. Do you generally have a positive or negative view of police?
I mean, positive. They're here to help us.
Would you agree just kind of with the general concept that, like any profession, there may be some good ones and there may be some bad ones?
Yes.
You acknowledge that they do a very dangerous job, right?
They do.
Not that every call is dangerous, but
Right.
you know. You were asked a few questions about your opinions regarding the justice system, and I'm referring kind of to the courts and, you know, the whole system, right?
Okay.
You asked you were asked, do you believe that the jury system in this country is a fair system? Why or why not? And you said yes, because it involves citizens randomly making bias or discrimination less probable, and because not all citizens have the same beliefs. Can you just expand on that a little bit more? How do you think that the jury system decreases the probability of discrimination by...
Because, I mean, you guys are not handpicking the person that's going to be here as a juror, so you pick 12 random people, you don't even know where they're coming from, what's their background, anything of that. So yeah, there's more probability than if someone is picking the person that he likes or whatever.
Right. It's not like I could just call 12 Minneapolis police officers to
12 of your friends, yeah.
Right, or 12 of my friends, right.
Mm-hmm.
Okay, that makes some sense to me. And then you asked, you were asked, do you believe our criminal justice system works? Why or why not? And you wrote, yes, it has been convicting and punishing the guilty, making them stop offending, and it somewhat protects innocence. Explain what you mean by that.
I mean, it's been working until now. You've been, like today, we're going to have him on court, and then go from there, take a decision. So,
Right.
So we're doing the job.
And your response kind of says the system works because it convicts people and it punishes people. That's how I interpret what you wrote. Am I wrong in that interpretation?
No.
You know that not everybody who is charged is ultimately convicted. Do you understand that?
Yeah, I just went on the side that, but I also put over there that it was
To protect innocence.
protecting innocence. So yeah, there's clearly criminals and there's people that are here in court and they're not criminals.
Well, there's this old saying that says, under our system, we would rather free 10 guilty people than convict one innocent person.
Yeah,
Would you agree or disagree with that concept?
I agree.
Professionally, again, without saying where you work, you're a route driver,
Yes.
and you expressed some concern about potentially losing your job over this.
Yes, but I mean, I talked with my manager, and doesn't look like it.
Okay.
I hope not.
All right. Well, that's because we recognize that jury service is a hardship for everybody because it
Yes.
takes you away from your family and your,
Yeah.
your work and whatever. So there's kind of two layers. So you have talked to your manager already about it?
About being on jury, and that's about it.
Okay, and that's fine. And you told him that if you were on a jury, it could be a long trial.
I didn't say that. I just said that if it would have any problem.
Okay. And your employer or your boss told you it shouldn't? They'll get your shifts covered or whatever?
Yeah, he said it shouldn't.
Okay. But you would potentially lose that income?
Yeah, we'll lose income and get paid. How much is it? $20 a day.
Yeah, being a juror is not a very high-paying job.
Yeah.
I guess the question is that financially, like, do you have? I mean, will you be okay if you weren't working for a month?
I mean, I think I'll be okay. It kind of sucks, but I mean, if I'm a good fit and I could help, that's okay with me.
Good. And that's kind of what you say is that this is a really big case, and that's why I would like to help and be a part of this. When asked if you wanted to be a juror.
Mm-hmm. Yes.
Your Honor, if I may have a moment.
Mr. Slisher.
Thank you, Your Honor. Juror number 36.
Hey,
Good morning.
good morning.
I've enjoyed getting to meet you a little bit this morning. You mentioned in response to defense counsel's question about what you would like us to know about you, that you are outgoing
Yes.
and that you're a family man. Is that right?
Yes, that's right.
I'd like to hear a little bit more, without providing identifying information, but just about your family and your extended family.
I mean,
Brothers and sisters.
they're not close to me right now, so whenever I have the opportunity, I go visit them.
Okay.
And yeah, I just rather be at home than going out.
How many brothers and sisters do you have?
I have 2 brothers.
Okay.
That's it.
And do they have spouses? You have nieces, nephews?
No, I'm the only one married.
Okay.
My brother is next. My little brother is the next one to get married.
Okay. And your parents, are they in the area?
No, they're not.
Okay. So what brought you to Minnesota?
Who brought me to Minnesota? I have cousins, uncles that live here. So yeah.
Okay. You also described yourself as outgoing, so I'm assuming you have a lot of friends.
I do. Yeah, I made friends here.
And in the area, do you have a fairly large friend group?
Yeah.
And you also talked a little bit about your management experience.
Yes.
And in the situation in which you're managing, what was the general age range of the employees you were managing?
I'll say like it was half. Half were high schoolers, and then in the morning we had older people,
Okay.
like younger than 60.
So with half of the people you were managing being high schoolers,
Yeah.
so the question about managing conflict and mediating disputes, did it help being an older brother to gain those management skills?
Yes, I'm not the older brother. I have an older brother.
You have an older brother.
Yeah, so
Okay.
I'm the one in the middle.
All right.
But yeah.
So tell me a little bit about that experience of managing high school students.
I mean, it just helped me grow up as a person. Like it just helped me having to help a lot of people. It was nice. I like that.
What were some of the biggest problems you have to deal with when managing high school students?
That most of them they just don't want to work. Yeah, they like to play a lot, so yeah, it was a little hard.
Getting them to show up and then
Yes.
getting them to work when they did show up?
Mm-hmm.
Okay. There was a question on the questionnaire regarding some general impressions you may have formed of George Floyd. And you stated that your general impression was neutral, but you added that if he had complied with officers' orders, this wouldn't have happened. Do you recall making that statement?
Yes.
Can you tell us a little bit more about what your thought process is there in making that statement?
I mean, it's just obvious if he wouldn't just complied, then that wouldn't happen. Maybe he just wouldn't been arrested and put in a cop car, and that's about it.
Do you think that that might affect you one way or the other in terms of coming to a decision regarding the conduct that occurred after he had been placed on the ground?
Can you repeat the question, sorry?
Sure. You indicated that perhaps if George Floyd would have complied with the officer, he would have just been arrested and this wouldn't have happened. But what I'm wondering is if that, if that belief that you have, that would somehow affect evaluating any conduct toward him after, he was placed on the ground.
Oh no, that wouldn't have any conflict.
Okay.
No, there's more to it.
I'm sorry, could you repeat that last part?
No, like there's more that happened than just that.
Okay. So, would you agree, or do you feel that even if the George Floyd was initially non-compliant, you still have to look at what happened and
Yes.
evaluate the conduct and the responsibilities
Yes.
separately?
Mm-hmm.
You agree with that?
I agree.
Okay. You stated in your questionnaire that you believed that you somewhat disagree with the proposition that the criminal justice system is biased against minorities. Do you recall that response?
Yes, I do.
Can you tell us a little bit more about how you've come to that conclusion?
And they're somewhat biased. I mean, a lot of it has to do with the media, and all they show is that they're being biased. So yeah, that's why I somewhat disagree, because I haven't honestly felt that or be in a position to feel that way. So yeah.
The media in the news, I noticed that you're also somewhat of a fan of true crime shows.
Oh,
Is
yeah.
that right? So tell me what true crime shows you watch.
I listen to a lot of podcasts. Like I said, I'm a route driver, so I'm always listening to podcasts. And yeah, it's just true crime stories. Crime Junkie.
Crime Junkie?
Like that. Yeah, that's what it's called.
Okay. How often do you think you listen to that podcast?
Whenever an episode comes out, I'm working 8 hours, so I have plenty of time to listen to different episodes. I don't only listen crime stuff, so
It's not all crime all the time?
No.
Okay.
No. So there's plenty of other shows that I listen to, news, sports, podcast.
But you did indicate in your in your questionnaire that you've always been fascinated with crime cases and how they're resolved. So it seems fair to say that you do have somewhat of a developed interest in
Oh, yeah.
crime. And, can you tell us a little bit about what draws you to those kinds of stories?
I mean, right now, it's everywhere. Like, you go to Netflix and there's a bunch of shows about it. I think that a lot of it gets just pushed to you. That's why.
Comes up on your feed.
Yeah, it comes up on my feed. I don't know if they're targeting me already or they know I like that stuff. So. But yeah.
I suppose I could ask you what else comes up on your feed, but that might draw an objection.
Right.
But in that, in following some of the crime story, I'm just wondering if you've ever considered pursuing a career in criminal justice or anything like that, law.
I haven't thought about it, to be honest.
Okay. So fair to say this is just a curiosity or an interest that you have among others.
Yeah.
Between that and you said soccer.
Yeah.
All right. If I may have a moment, Your Honor. Thank you very much, Your Honor. No further questions, and we pass for cause.
All right. Juror number 36, you will be on this jury. Couple of things. You're going to be on your own. You can go back to work if you want.
Okay.
But we need you to report March 29th by 9 a.m. And we expect the trial to start on that day and proceed for probably 4 weeks. If there's any change in the schedule, for example, if we get a delay for some reason, we'll give you a call and let you know. We're probably all going to give you a call to remind you anyway, so be prepared for that.
Okay.
Please do not investigate, do not read about this. In fact, if you could affirmatively avoid media coverage about this or any podcasts that involve this case, that would be greatly appreciated.
Okay.
But do you have any questions for me?
I do not.
Okay, then you're released for the day. We'll see you March 29th.
All right. Thank you.
Yep. Oh, one last thing. You did receive a letter with a sticker on it.
Mm-hmm.
Keep that. You'll need that on March 29th to get back in the building.
Sounds good.
Thank you.
Thank you.
All right, let's do juror. Let's make a record on the one juror. Was it 40?
43 or 45?
Mr. Schaefer.
It's 43.
All right, juror number 43 returned their questionnaire saying no English, no English. That was the answer for everything. I would also note, if counsel was not aware, that person also did not return their initial qualification questionnaire to determine the basics of whether they're a resident of Hennepin County, a citizen, etc. But I think the parties have reviewed this matter and are agreeable that that person be stricken for cause. Mr. Slisher?
Yes.
Mr. Nelson?
Yes, Your Honor.
All right. Morning. All right, you are juror number 37, correct?
Correct.
All right. Before I turn it over to the attorneys, we're going to do a couple things first. Well, first, I want to swear you in so that all your answers are under oath. You'd raise your right hand. You swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror.
Yes.
All right, thank you. First of all, you filled out a questionnaire, and thank you for taking the time to do that. I know it took a long time. It was rather long, but you obviously paid a lot of attention because there's a lot of detail. Was everything true that you listed in that questionnaire?
Yes.
All right. Since you filled out the questionnaire, some time has passed, and it's very common for jurors to realize they forgot something or needed to change something, or even that their opinions have evolved. So I would ask you, since you filled out the questionnaire, is there anything you wanted to change or add or delete from that?
My opinions may haven't evolved, but I'm not sure.
Okay. I think the attorneys might explore some of that. Is there anything right off the top of your head as far as opinions
No.
that have changed that you think might be important to know?
No.
Okay. The questionnaire also advised you not to read any newspaper articles or and to avoid media about this case since you are a potential juror. But since it was filled out months ago, it's not that uncommon that people inadvertently see a headline or a friend might say, "Did you hear about this?" And since we told you don't tell anybody you're a potential juror, you can't exactly stop them. So did anything like that happen to you where you received more information inadvertently, either seeing a headline or friends talking or something?
I've seen headlines, yes.
Okay. Do you recall specifically what any of the headlines were and when they were?
No.
Okay. Any substance about the case, procedures, any of the parties involved?
No.
All right. Okay. Now, and the whole point of a lot of this is everybody who's come into this courtroom has heard about the case and knows a certain level of information. But regardless of how much or how little you know, the important thing is that you put aside any information you may have learned in the media or from anywhere for that matter and decide this case only on what you hear in the courtroom. Do you think you could do that?
I'm unsure.
I'm sorry?
I'm unsure.
You're unsure. Okay, can you tell me a little bit about that? Because, and I'm sure the lawyers would say the same thing, you have to be fair and impartial, and people will honestly say, I would try. I've never met a juror who wouldn't try. But some people say, but I know I could not put it out of my mind, for example. Or, I've read it, I understand, I can put it aside, I know myself well enough to know that it would not infringe on the decision I'm going to make. Tell me about that.
I will try, but there's no reason. I've seen the video, so I can't unsee.
Right. And is there anything else about the case that you think might be impossible to let go that you've heard about outside the courtroom?
The length of the time that it happened.
Okay. So the actual fact that was depicted in the video.
Mm-hmm.
Okay. The other thing is, and these kind of go together, what you know about the case may have given you certain opinions about the case already. And that's fine. I think just about everybody who's been exposed to information forms an opinion of some sort. And it may not be about guilt or not guilty, maybe more moral judgments or things like that. Can you put those opinions aside and not have it come into the jury deliberation room?
Yes.
Okay. So bottom line is, we're looking for a jury who can be fair and impartial, and the essence of that is that they decide the case according to the law based on the evidence alone that you hear in the courtroom and nothing else. Knowing yourself, do you think you can put aside everything else, opinions, what you've heard outside the courtroom, and decide the case? And we're looking for your honest answer. Could you do that, you think, in this case?
As far as opinions, yes.
Okay. What about facts you may have seen in the media? Could you put that aside?
Not facts, no.
Okay. And is that mostly about the video that was seen?
Exactly.
Okay. All right, I'm going to turn it over to the attorneys. Oh, I forgot to ask you. Did you recognize any of the witnesses who were listed on that long list of witnesses?
No.
Okay. And the trial time is going to be about 4 weeks once we start on March 29th. I think you did indicate some concern with jobs and that. I'm going to leave that to the attorneys to explore, but do you think it's to the point where you could not serve? Or could you make arrangements? Could you make it work?
I'm a single parent, so I have limited support.
Okay. Well, the jury for deliberations would be sequestered, which means you'd be staying in a hotel till there was a decision made. How would that, as a single parent without a lot of support, what do you think that would do?
I possibly wouldn't be able to.
Oh, I'm sorry.
I possibly wouldn't be able to do it for entire 4 weeks or however long it took.
Okay. Right now, during the trial itself, we don't anticipate the jury you'll be able to go home every night during the case itself. That may change if circumstances require it, that I may, in the middle of the trial, say, now you've got to go to the hotel. I don't think that's going to happen, but you definitely would have to stay in a hotel during deliberations, which, how long deliberations go is entirely up to the jury. I mean, it could be an hour, it could be days. How do you think that would affect you in your situation? Is that doable?
I am unsure if that's doable because we don't know how it's going to go, but I will try my best.
Okay, thank you. I'm going to turn it over to Mr. Nelson for further questioning. Juror number 37.
Good morning, ma'am.
Good morning.
And I should say, if you feel comfortable, you may remove your mask if you'd like. We have plexiglass, and I'm going to keep my mask on. But totally up to you. If you feel more comfortable keeping the mask on, feel free to do so.
Okay.
How are you today?
Good.
Good. I was having a little trouble hearing a couple of your answers, and unfortunately, I don't think that microphone moves. So if you could get a little closer, that may help. Thank you so much. And thank you for coming down here. I think you were here yesterday as well and back down here today. So I just want to thank you for your patience. Sometimes these things take a little bit longer. So here's what I'd like to do is ask you some kind of general questions and about just to get to know you a little bit better, a little bit more about your life. And then I'm going to focus on some of your answers to the questionnaire. Would that be okay with you?
Yes.
Okay. So, juror number 37, let's assume you and I met at a party or some social event. What are a few things you would want me to know about you when I walked away from that conversation?
Nothing personal, maybe my name, age.
This completely unrelated to this case. We're just two strangers who bump into each other in a social situation. You wouldn't want me to know anything about you?
No,
Why?
because you're a stranger.
Okay. How do people go from being strangers to friends?
By conversation.
Okay. Would you entertain a conversation with me?
Yes.
Okay. So, again, let me just say, are you nervous today?
No.
Okay, good. I promise you that I'm not trying to trick you or anything like that. I just need to know a little bit more about you so we can see if you're the right person. I'm going through the same process with every single person.
Understood.
Okay. So, I'm not asking you to reveal personal details about your life here either, okay? But we do have to pry a little bit. So again, take all of this out of the equation, right? My friend and your friend are friends, and they introduce us. We're sitting there. We're two people. We're talking. What would I walk away knowing about you? What's important to you?
Probably that I am a mother. A little bit about my career. Probably where I'm from.
How many kids do you have? Remind me.
2.
2. And just their ages? How old are they? Are they younger?
Yeah, they're younger.
Okay. Great. You received, as I understand, a letter from Hennepin County saying you were going to have jury duty, right?
Correct.
When you opened that first initial letter, what was your reaction to that?
Oh, man.
Why, oh man?
Because it's a pretty high-profile case, and it's important.
Sure. And again, everybody who has come in here has heard about this case and has had a somewhat similar reaction. So it's great. So were you concerned about your security or your safety when you read that?
Yes.
Okay. Can you explain to me a little bit more about that?
With a high-profile case, I know everything becomes public. So depending on what's ruled, that could be a problem later on down the line or even in the process.
Okay. And so you would be concerned that people would learn your identity, and again, we're trying everything we can to not let that happen, but you'd be concerned then for your personal well-being?
Yes.
Okay. As well as your children, I'm assuming, too.
Of course.
Now, when you came downtown yesterday and you saw the situation outside, you know, the military and the police and the fence and all of that, did that raise your level of concern or make you feel safer?
I felt safe, but it also raised my level of concern.
Okay. How so?
Just seeing the action that needed to be taken. But once I got here, I felt safe. Okay.
So I missed one sentence in there because I was trying to get comfortable, which is hard to do here. You said something about the actions being taken.
Just seeing the level of action that needed to be taken in order to just do this part of the case.
Okay, gotcha. And then once you got inside the building, you felt safe and...
Correct.
Good. When you heard yesterday that your face isn't going to be on TV, did that make you feel safer?
No.
Okay. Are you concerned about that? About the fact that this is being televised?
No.
Okay. So can you tell me about a situation or think about a situation in your personal or your professional life where you have been called upon to resolve a dispute between two people?
Yes.
Okay. So how do you go about that process in your personal life? How do you resolve a dispute between two people?
Well, I want to hear both parts of the story and make a decision on who was wrong and who was right.
Okay.
And explain my reasoning.
All right. And how you listen to both sides of the story, right? Are there any other steps or tools, so to speak, that you think that you could use to help decide right or wrong?
I guess it's about who I feel like is telling the truth.
Mm-hmm. So it's an intuition? Or are there things that you could, like for example, maybe talk to another person who was there?
Yeah.
Right.
It's not intuition. It's about talking to another person who was there, or are both of their stories lining up and somewhere went wrong, and based off that, those.
All right. And so you are, in this case, let me just put it this way. In this case, there's going to be a lot of evidence that's admitted into this case, right? And we know, based on your questionnaire, that you've seen the video, you've referenced this video this morning, right? But we're telling you also that this trial may take a month to hear, right? To get all of the evidence in front of you. Are you willing or are you able to set what you know about this case now aside and judge this case based upon the evidence in court?
Like I mentioned before, there's video surveillance, so I can't unsee the video. So I'm not able to set that part aside
What if I were to tell you that there's a fairly high probability that that video that you've already seen is going to be evidence in this case? So you're going to see it again.
It's still going to be traumatizing to me.
Okay. And again, you know, what we're trying to do here is just to find out if you're the right person for this case. And so again, I don't mean to pry or anything. I just want to make sure that you're the right person.
Yeah, I get it.
Okay, good. And we'll kind of come back to the video and some opinions and stuff in a little bit, okay? Can you think of a situation in your life where you were certain about something only later to be shown that you were wrong?
Yeah.
Let me ask you, how did you deal with that?
I want to take accountability for it.
Okay. Are you the type of person that's willing to re-examine your own views? Or are you the type of person who, once you've made up your mind is made up?
I can re-examine my own views, but I always want to hear what others may think of it. I can't just make that decision on my own.
Okay, great. So I'm going to ask you some follow-up questions on your questionnaire. And I know that you haven't read this in a couple of months, right? Again, and I'm telling every single person the same thing. I'm not trying to trick you, but there may be some things you wrote down. I'll read them to you, and we may have some follow-up questions. But if I can have 1 second to confer with counsel about something.
You may.
Sorry about that. It's kind of weird to know we're talking about you, huh? I had to clarify something with Mr. Slisher, who is one of the attorneys for the state. When the judge was asking you beforehand about what you wrote in here and how your views may have changed since then, I believe that you said your views have evolved since you filled this out.
They may have, yes.
They might have.
Yeah.
Okay. Nothing specific or nothing like kind of global but as we go through this, there may be things that you've changed your view on.
Exactly.
Fair enough. And we all know that, again, everybody wrote this like in December, I think, and it's now March, and one person so far has actually kept a copy of it, so, all right. Okay, so you said before that your, that you obviously had heard about this case.
Yes.
Right. Everybody in the world has, right? Okay. And you wrote kind of a dissertation or a lengthy paragraph about what you had seen or what you had heard in the news, and I appreciate that. Oh, before I go on, I have one other question. Do you have concerns about COVID being in the courtroom?
No.
Okay. All right. So one of the questions is that from what you have seen, read, or heard, do you have a general impression of the defendant? That's Mr. Chauvin. And it gave you a series of choices from very negative, somewhat neutral, somewhat positive, very positive, or other. And you selected very negative.
Correct.
All right. One thing I'm going to just tell you, and again, I've been telling this to the other jurors too, is that you have every right to have an opinion, all right? And I'm not questioning your right to have any opinion that you have, but we need to know what those opinions are, again, so we can determine if you're the right juror, right? Okay. So you chose very negative, and do you share that same perspective today? Has this evolved?
Yes.
Okay. So you still view him very negatively?
Yes.
Okay. And when it was asked, why do you feel that way, it said, watching his face as he kneeled on someone's neck, he looked so hateful. Can you explain what you mean by that? Whose face? What are you talking about?
The officer who kneeled into George Floyd's neck, just watching it.
You're talking...
Watching the video, looking at his face. He looked...
Looking at Mr. Chauvin's face?
Correct.
Okay. That's what I wanted to make sure.
Yep.
And you felt that he had a hateful look on his face?
Yes.
And your feelings towards Mr. Floyd were neutral because you don't know Mr. Floyd or anything about him?
Correct.
But you also had seen some media that his family expressed that he was a good guy, a nice guy, right?
Correct.
Okay. Now, there was a question asking you how many times you've watched the video. And I want to just, before I want to clarify what we mean by the video. There was a video that a bystander took, uploaded it to Facebook. That video went viral, right? Is that the video that you watched?
I'm pretty sure it is.
Okay. Now, there's been other videos that have also been released from other bystanders. I think a few kind of made their rounds, and some body cameras from police officers and things of that nature have been released as well. Have you seen any of those videos?
Yes.
Okay. Have you watched all of those videos?
Most of them.
Okay. And how many times have you watched those videos?
I would say about 3 or 4 times.
Okay. And was that before you filled out this questionnaire or after you filled out the questionnaire?
Before.
Okay. And so the video that you, the Facebook video, we'll call it, you said that you'd watched that one time?
Yeah, the one where you can hear him crying out for his mom. Yeah, I was only able to watch that one time.
Okay. But you have watched the other videos more times.
Correct.
Okay. And then in terms of that Facebook video, I presume you've seen snippets here and there on the news if you walk past the TV and it's on?
Yes.
Is that fair to say?
Yes.
And so you may have seen smaller segments of that video here or there, right?
Correct.
Okay. But as far as watching that Facebook video from start to finish one time, right?
Correct.
And you said something that you also wrote in your questionnaire, that about your conversations with your friends and family members and colleagues, that you've had conversations with those types of people, right?
Yes.
And you wrote that you cried hearing him call for his mother during his last minutes of life.
Yes.
So that you had a very strong emotional response to that.
Yes.
Right? And I think you've referenced both here today and elsewhere in your questionnaire that once you see that, you can't unsee it.
Correct.
Right? One of the questions in the questionnaire asks you about your ability to view graphic or otherwise sensitive material. Are you okay with that?
No.
So you may have to watch that video again here in court. Would you be okay with that?
In that case, yes.
But other graphic stuff like medical photographs or things of that nature, you would not want us to look at?
I don't want to, but if the need is here, then I will.
Okay, all right. That's what I needed to find out. You were asked a question about what I would describe as sort of the aftermath of this incident, you know, the protests, the demonstrations, and ultimately the riots. And you were asked whether you thought they were positive or negative. Do you remember that?
Mm-hmm.
And you said they have been negatively, your community has been negatively affected and positively affected. And that's what you wrote. Can you just further explain that a little more?
I mean, negatively affected because there was a life taken. Positively affected because it's become a movement, and the whole world knows about it.
So that's the good thing that's come from this. And I guess what I'm curious about is the like the property damage and things like that. Would you define that as negative?
I feel like if that was what needed to happen in order for this to be brought to the world's attention, then that's what needed to happen.
Okay. The question that comes after that is, no matter what you have seen or heard about this case, and no matter what opinions you might have formed, can you put all of that aside and decide this case only on the evidence you receive in court, follow the law, and decide the case in a fair and impartial manner? And you wrote, yes, I can be fair and follow the law, but I cannot unsee that video. Right?
Correct.
So the video has had a really pretty profound impact on you, right?
Mm-hmm.
And
Yes.
sorry. So this is the really kind of the question at hand, right? Is you have a very strong opinion about Mr. Chauvin. Would you agree with that?
Yes.
You have a very strong reaction to seeing that video, right?
Yes.
And you have strong opinions about the movement that has come out of this incident, right?
Yes.
All of which are perfectly valid for you to hold, not questioning that. Do you, I don't know what's in your heart, right? I don't know what's in your mind. I got to take whatever you say at face value, right? And I have to believe you. And this is what I'm asking you to do is, looking in your heart and looking in your mind, can you assure us unequivocally that you can set all of that aside, all of that, and focus only on the evidence that's presented in this courtroom?
I can assure you, but like you mentioned earlier, the video is going to be a big part of evidence. And there's no change in my mind about that.
So you have formed an opinion specifically as to whether Mr. Chauvin is guilty of this case.
I have not.
You have formed an opinion about what transpired on that video.
Yes.
And there's nothing that can change your opinion.
No.
Would the court like to inquire further?
No. Is he like to inquire?
Yes, sure.
Okay.
As to this issue?
Ask him to see if he can
Good morning.
Good morning.
Just I need to clarify some things that you said regarding, what you've seen, how what you've seen made you feel, and then what you would be asked to do if you were a juror here. Okay? And you said, I think, several times that you could set aside any strongly held opinions. Is that right?
Right.
Okay. And you could set aside any strongly held beliefs in deciding this case. Is that right?
Correct.
Now, if you were a juror in this case, the judge would give you instructions as to the law. And you would have to listen to those instructions and follow those instructions without regard to any beliefs or opinions that you had before coming in and hearing any evidence. Would you be able to do that?
Would I be able to follow instructions?
Yes.
Yes.
And if those instructions, if the judge gave you instructions, and if you followed those instructions, it meant that you had to return a verdict of not guilty. Would you be able to follow those instructions and return a verdict of not guilty?
That decision is not solely made by me, correct?
That's correct. But if you, in looking at the instructions, I'm listening to the judge's instructions, I see what all of the elements are, I know what the evidence is, right? I've seen it, I've seen the video, I've seen everything, but if I listen to the judge's instructions and follow them, I would have to find the defendant not guilty. Would you be able to do that? Find the defendant not guilty if you believe that the instructions required you to do so.
If I was required to, yes.
Okay? And so it sounds like you've formed, some opinion. You had an emotional response to some things that you saw.
Correct.
But you would be able to keep that in context and understand that your job as a juror would be to look at the evidence as presented in court, listen to what the judge tells you, and follow it exactly, no matter what the result. Is
Correct.
that right? Yes?
Correct.
And you're sure you can do that?
I will try my best.
Yeah. Well, and then, we have to make sure, because our job here is to try this case, and we have to do so fairly. And you would agree that every defendant, no matter what they're accused of doing, has a right to a fair trial. Do you agree with that proposition?
Yes.
And in order to get a fair trial, it's important that every juror can look us in the eye, raise their hand, and swear that they can be fair to every defendant and to evaluate the evidence and follow the law. And not that they'll try, right? Not that they'll do their best, but they will do it. And so we're just asking you, do you believe in yourself that you could do that? You could follow the law, listen to the instructions, and decide this case on its merits no matter what way it cuts?
Yes.
Nothing further, Your Honor.
I'm going to follow up with a question. I want to make sure you understand that sometimes jurors come in and they think that if they give a certain answer, if they say, I can't be fair and impartial in this case, that's somehow a failure. It's not. If that's what it is, it's every case is different. It involves different issues, and we all bring our differing backgrounds here. And I'm not questioning your answers. I'm just saying I want to give you the space to say, because you're not failing. If you are giving honest answers, that's all we require. There's no failure in saying fair and impartial. And if that's what you want to say, I absolutely accept it. Don't get me wrong. I just want to give you the space to be able to say one way or the other. Do you think that I'm going to focus on one issue, and that's the presumption of innocence? The defendant is presumed, as I told you yesterday, the defendant is presumed innocent of the charges made. And the fact that he's on trial cannot be held against him, or the fact that he's been charged. Do you think you could do that, is presume that he is innocent as you enter the courtroom?
I wouldn't like that verdict, but
Okay, so if it was not guilty, but right now you're supposed to, as opposed to at the end of the case, right now you're supposed to presume he is innocent. And you said something about you can't unsee that video. Perfectly legitimate observation. Do you think with that it would be hard for you to presume the defendant innocent during the trial?
I do.
All right. Sidebar? All right, Juror 37, I'm going to excuse you. I want you to make it very clear. As I said before, we're not doubting your fairness or impartiality. I think there are some legitimate concerns you have that I want to honor. And so I'm going to release you at this time. Thank you for filling in the questionnaire and being as open as you were. And you are released from jury service for this term, so you don't have to report anywhere unless we give you a summons maybe years from now. Thank you so much.
Thank you.
We're going to take our morning break at this time. Let's reconvene at 11. We'll make a record of we'll wait for them since. Yeah, we're gonna make the record first and then. We're not on the record yet, Dana, but paging Miss Wong to the courtroom. We're missing our other pool person. The gentleman from, oh, there he is, okay. All right, we are on the record. Last year was struck for cause by the court on the motion of the defense. Mr. Nelson, you wish to make your record, and then I'll turn to the state.
Here or at the record?
Wherever. In fact, if you'd remain seated so you can pick up the microphone.
Yes, Your Honor, the defense made a motion for cause. There were several concerns about this juror made several equivocal statements about her ability to be impartial in terms of how the video or her previous viewing of the video had impacted her emotionally. I recognize that this juror said that she could set aside her opinions. However, whenever pressed, even by the state, she had a very difficult time acknowledging that she could apply the presumption of innocence because of her viewing of the video, and that it would be essentially that she had already made up her mind in this case. And that was essentially the basis, Your Honor, for the cause.
Mr. Slisher.
Thank you, Your Honor. The state opposed the motion to dismiss for cause for this juror. I don't believe she equivocated at all. I think that she stated very affirmatively and unequivocally that she could set aside her opinions, that she could set aside her beliefs, that she could apply the presumption of innocence. She stated it on a number of occasions, and she was questioned about it on a number of occasions, despite unequivocally stating so. What she said in terms of applying the presumption of innocence is that it would be difficult, but that she could do it, and that she wouldn't like the verdict, but that she could render it. And when you have somebody who states as thoughtfully as she seems to have considered her answers under oath, that she would follow the instructions and decide the case based only on the facts that are presented and on the judge's instructions, then I think that that is not a proper removal for cause. If the counsel would have wanted to use a preemptory challenge, he has plenty. He has 15 preempts that he could use. Those are extra preempts that have been given to him to account for some of the sensitivities in this case.
Well, let's be fair. Both sides have been given.
That's true.
Triple the normal.
That's true. We're entitled to 3. They're entitled to 5. You gave us 9. You gave him 15. So I'm not saying that's unfair. What I am saying though is that was not a proper cause strike. I believe that she very clearly stated her opinion, and she was questioned over and over. And I think that perhaps a little bit more than other jurors. And I would just state that I don't think that it should have been granted, and we object to it.
The court did excuse the juror for cause. To be honest, I was evaluating as we were going along, and I don't think it developed immediately, but she was very consistent in saying that she would put everything aside, but she couldn't unsee the video, which is, I think, just another way of saying I couldn't put that aside, what I had seen earlier. Granted, it's probably going to be in evidence, but it's that concern that she has about not being able to unsee the video. She had a very strong emotional reaction to it. She said she cried. She has a very negative opinion of Mr. Chauvin, all of which does not constitute cause. But the bottom line being, it seemed to me that she was walking into the courtroom, especially when she said, I could render that verdict, but I wouldn't like it, is that she was not in the middle, neutral, but actually, which is why the court asked the presumption of innocence question. And when I finally gave her the space to say, how do you feel? Do you think sitting here right now, and it has to be right now, not later, can you presume the defendant innocent? She answered unequivocally no. That's the primary reason why I granted the cause challenge. I think there was sufficient, I agree with you, there's sufficient other things if the defense had wished to use their peremptory strike. She also had issues with child care as a single mom without a lot of strong support, but that was not the basis for the court's challenge because she did say she could be able to work through those. So, with that, we'll go to the next juror. Thank you.
Thank you.
This is juror number 38.
Is this our last juror from yesterday?
Mr. Schaefer, is this the last one for this one? All right. Come on up. Morning, you are juror number 38, is that correct?
Yes, Your Honor.
All right. Well, a couple of things before I turn you over to the attorneys to ask questions. First is, I'm going to swear you in so that all your answers to the questions are under oath. So raise your right hand, please. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you.
Can I?
I was just going to say, we have COVID restrictions here, which include masking, but we have plexiglass between us, and I will be keeping my mask on, but I think that allows you to undo your mask if you'd like.
Thank you.
So feel free to do that during the questioning. The attorneys similarly, because they're behind plexiglass and quite a distance from you, will also be allowed to remove their masks. First of all, you filled out a questionnaire. Thank you for doing so. You put a lot of detail in, so it's clear you spent time on this. Is there any, or first of all, was everything true on that questionnaire?
Yes.
Is there anything you'd like to change or amend because you filled it out back in December, and on reflection you might think, well, I should have added this or deleted that, or even that my opinions have evolved on certain issues? Anything that you can think of as you sit here right now that you would want to change?
None that I can think of right now.
Okay. The attorneys will lead you through very specific questions, and so if that, and they'll usually give you what your answer was, because most people have not kept a copy of their questionnaire. Feel free to change your answer. Okay? And if you have any questions about what your answer was, I'm sure they will give it to you. So, you were not supposed to read any articles or watch any media related to the case. That was part of the questionnaire. Since you are a potential juror, don't look at anything about this case. But we recognize that was back in December. Inadvertently through the months, you may have been exposed to something just by seeing a headline, talking to a friend, something like that. Have you learned anything else about this case, whether it's facts, parties, procedures, pretrial matters, between when you filled out the questionnaire and now?
No, I have not.
Okay, thank you. Did you recognize anybody on the witness list?
I did not recognize anybody.
Okay. Now, going back to the questionnaire, you understand the reason why we ask all those questions is we want to know what your level of knowledge is and also the opinions. When you come into this courtroom, if you are on the jury, you have to decide this case just on the evidence you hear in court and follow the law that I give to you. Do you understand that?
Yes.
So in other words, you got to put aside anything you've seen or heard elsewhere, and even you've got to put aside any opinions you may have held about certain things, maybe opinions evaluating the case or what you've seen. Do you think you could do that?
Yes.
All right. And as I'm sure one of us will say, it's all right to have those opinions. We're not questioning the validity of any of those opinions. It's just we need to know if you can put them aside so that both sides have a fair and impartial trial.
Understandable.
Any questions about that?
No questions.
Think you can do it?
Yes.
All right. We also talked about the length of trial is about a month starting on March 29th. Do you think you can accommodate that schedule?
Yes.
All right. Anything else? Any questions for me?
No.
All right. I'm going to turn it over to Mr. Nelson, juror number 38. You may inquire.
Good morning, sir.
Good morning, sir.
Here's what I'd like to do, with your permission. I'm going to ask you a series of general questions, kind of get to know you a little bit, and then I want to follow back and circle back on some questions that you answered in your questionnaire. All right? Not trying to trick you, promise. Just trying to determine if you're the right juror for this case. Understood?
Understood.
All right, great. So if you and I were to meet in some social situation, a party or wherever that may be, what are a couple of things you would want me to learn about you in that conversation?
That I'm a stand-up guy, and that the type of person that would do anything for my friends or family.
Okay. So loyal to your friends and family?
Yes.
Okay. You got a jury duty notice, like you got I think an initial sheet saying you have jury duty, right?
Correct.
When you got that first sheet that says you have jury duty, what was your initial reaction?
I think the initial words that came out of my mouth is, how'd they find us again? Because I just recently moved to Minnesota.
Okay.
So that was my initial reaction.
Okay. So how long have you lived in Minnesota?
Just over 3 years.
Okay. And you, I think if I recall from your questionnaire, you actually had previously served on the jury?
I did.
Okay, we'll talk about that more later. But sort of like, I just moved here, how'd they catch me?
Yeah.
Right.
It was more of a sarcastic statement, but
Sure, understood. How about when you learned about this, you got a packet of information that you filled out, when you learned that you were a potential juror on this potential case?
I think my initial reaction was just, okay, this is big.
Okay,
But it's one of those things, it's a random draw. I think that was my initial reaction.
okay. Did you have concerns for your personal safety at that time?
Not at that time. When I did fill out the questionnaire, as you know, I did have concerns just for the safety of not necessarily myself, but my family.
Okay. And when you came down to the government center, I believe yesterday you were here as well, right?
Correct.
When you came down to the government center and you saw its current condition, what did you think about all of that?
Frankly, I just looked like there's more construction on a building.
Okay. It didn't make you feel safer or alleviate those?
No, not at all.
You just thought it was construction courtesy of the National Guard, right?
Well, I mean, when you open up where we come in, yeah, the heart rate elevated a little bit, but not to an extent where I was nervous or scared or anything like that.
Okay,
But I think that's a normal reaction for anybody.
sure. When you got the initial instructions yesterday in terms of your anonymity and remaining anonymous, did that address any of your safety concerns?
That addressed it,
Okay.
perfectly addressed it.
Okay. So you know that at some point it's possible that your name, I don't know when, but your name, if you were to serve on this jury, could be released.
Yes.
Okay. Does that cause you any concern?
No.
Now, ultimately, sir, again, our job is to find whether you're the right guy for this job, right? It's kind of like a job interview in a weird way. So I'm going to ask you a series of kind of general questions again. Can you think of in your personal or professional life or in any of your activities where you've had to you've been called upon to resolve a dispute between two people?
Not necessarily in my personal life, just because over the past year, we've all been kind of isolated
Sure.
with the circumstances.
Right.
if I'm looking back from my professional standpoint, there was a time where I had to resolve an issue between one of our reps/employees and a customer. And I know most of us in society, you know, there's a saying, the customer is always right. I don't necessarily believe in that 100%, but I do believe it. And there was a dispute between a customer and a rep, and had to listen to both sides, because ultimately I wanted to jump right to, well, the customer's right. But I listened to both sides because they're both adamant. And then at the end of it, you know, it came down where the customer was right, but with certain circumstances that I understand why our employee handled it the way he or she did.
Gotcha.
So
You kind of answered what was going to be my next question, but if I can unpack that a little bit. So in resolving disputes, one thing that's important is to listen to both sides. Would you agree with that?
Oh, of course, 100%.
Okay. And were there other measures that you could take in that situation to try to verify who was right?
Well, I talked to both parties, of course.
Right.
I tried to understand it, you know, and initially I went in just assuming that the customer was 100% right. So, you know, you look at the employee and you just look at that in a different way. And I think after just talking to both sides, it, you know, it was like, yes, I believe the customer was right, but with exceptions.
Right. Gotcha. Okay. So just generally thinking then, outside of the context of that particular circumstance, are there other tools or methods that you can employ to try to resolve a dispute between two people?
Well, I think keeping an open mind. I mean, obviously, that's common sense. I think listening to both sides and just trying to evaluate with the best information that you have at hand.
Right.
Without any, you know, listening to other people around or other factors involved, just what I have in front of me. And that's what I try to do when I resolve disputes.
So if you're selected as a juror in this case, one of the things that you would be potentially having to do is try to resolve disputes between jurors, right? Or between how do we look at this piece of evidence. So take a hypothetical situation. Some piece of evidence comes in at this trial, and you think that this is the most important piece of evidence. But another one of the jurors looks at that same evidence, sees it completely different than you do, and thinks it's irrelevant, right? Or it's not a part of the equation. The first question I guess I have is, how do you try to resolve that question over that piece of evidence?
That's a good question. I don't know if it's my responsibility to try to persuade the other juror or person, or just take that information, what's in front of me, and base my decision based on that. So if I think it's the most important, somebody else thinks it's irrelevant or doesn't see that, I don't know if it's my job to persuade them or their job to persuade me, but for me to evaluate it based on what I see.
Okay. Is it possible, and meaning you have a job to evaluate it for yourself on one hand, and you are going to have discussions about how important pieces of evidence are?
Oh, of course.
Right.
I mean, I know if I sit on this jury and we go into deliberation, we are going to have those conversations.
Right. And some of those conversations may be disputes, right?
Correct.
And ultimately, you know that any verdict that would be rendered needs to be unanimous.
Correct.
Right? So that means all 12 jurors have to agree. So the question becomes is, are you the type of person, let's take that example, right? You got this single piece of evidence. You're the only one now who thinks that this is the key. Are you the type of person who stands by his conviction, or do you simply agree with others for the sake of consensus?
I would say that I'm more of a person that stands by my own conviction, because that's who I am, and that's, in my opinion, that's all you have as a person, regardless of where we are here today. But that's what everybody should have, their own conviction, their own beliefs.
Right. And so ultimately, you understand that I don't think that there's going to be one single piece of evidence, right? Your job as a juror is to listen to all of the evidence. Can you do that?
Of course, yes.
You've already said you in the resolution of dispute, at least you understand it's important to hear from both sides. Can you hear from both sides?
Yes.
So the defense has no obligation whatsoever to present any evidence. We don't have to ask a single question. We don't have to do anything. We could sit here, right? And the burden still remains with the state to prove the case beyond a reasonable doubt. Are you okay with that?
Yes.
So if Mr. Chauvin didn't ask a single, or through me did not ask a single question, didn't submit a single piece of evidence, would that affect your, in other words, you're not hearing from the other side, right?
Right.
How would that impact your decision-making process?
It wouldn't affect me because of what you just said. If you're not obligated to do that, you don't need to, so I don't think that should affect me at all.
Now, can you think of a circumstance in your life where you've been 100% convinced you're right, only to later learn you were in fact wrong? Dude.
Is this something more sensitive?
Maybe.
I am going to find under Minnesota Rule of Criminal Procedure 26.02 subdivision 4, parent 4, matters to be discussed are deeply personal for the juror, and we will go off audio. What that means is we're shutting off the audio being broadcast outside this room. Everybody in the room can still hear it.
Okay.
But and it will be reported and made a matter of record, but is not being broadcast today.
Okay.
Okay? Did you?
Driver's seat in that regard.
All right. And we are back on audio. Then.
We're going to do everything we can to obviously maintain that anonymity, right?
Thank you.
And so, all right, I think I've asked all my general questions. So let me ask you a few questions. Again, not trying to trick you. I know you haven't read this in quite some time. Obviously, we all have. All right. So the first question you were asked about was just to kind of give a little bit of a description about what you knew about this case already, right? So it's fair to say, sir, that you were very or at least familiar with this case before filling out this.
That's fair to say.
And you became aware of this case at the time it happened.
Yes.
And what you wrote is that, in part, was that a knee was placed over his, meaning Mr. Floyd's neck, which limited his breathing, and he shortly passed away after that. Right? So in terms of the phrase limited his breathing, Was that information that you got from the media? Was that based on what you perceived in any of the videos, or how did you come to that conclusion?
I came to that conclusion because of the small clip that I saw where he was saying, "I can't breathe." So that's where I drew that conclusion.
Okay.
From that specific clip.
Okay. And so you you have seen, I believe, and you indicated that you have seen some clips on the news and things of that nature, right?
I have.
So I'm trying to do this for everybody, which is when we talk about the video, what we're talking about is a bystander to this incident took a cell phone video, uploaded it to Facebook. That video went viral, and then that video led to massive press interest, right? So that's the video I'm talking. Have you seen any other videos associated? Does that sound like the clips that you are describing?
I have not seen the Facebook video. I have not seen the video on social media whatsoever. It was more the national news,
Right.
In that 5-10 second clip, but I have not watched the full video in its entirety at all. Anything on social media I haven't watched,
Okay.
even before I filled out the questionnaire.
Right. And so that was kind of a follow-up question, but I'm assuming you're a consumer of the news to some degree, whether it be on your phone or on the television or maybe not in the print form anymore. But you're a consumer of the news, and have you seen that clip or some variety of clips multiple times, or how many times would you ask?
I mean, at some point when you watch the news, it's kind of hard not to see it.
Right.
But I would say 1 to 2, 3 times tops. It's not one of those things that we sit at home and watch news all night long. I
Right.
mean, we have a pretty active life where we're not, watching the news.
Right. Okay. Fair enough. Now, you were asked your opinions as to my client and Mr. Floyd, and I believe that your response to both was the same. You checked that you were neutral as to both, and you wrote, "I don't have all the details of what actually happened." Why did you write that, and why is that important to you?
I put it neutral because I've never met. You only talk to both as individually or separately.
Both.
I've never met Mr. Floyd. I don't know his background, so I don't know who he is. I've also never met the officer, so I don't know his background, what's in his head and what's in Mr. Floyd's head. So I just put neutral because I base my, when I meet somebody, that's where I'm able to form a judgment or, have an opinion, but I haven't met either of them. So I think I wanted to try to be true to myself and saying, how do I have an opinion when I've never met them?
Okay. And did you form an opinion, any opinions whatsoever about the case based on the media presentation or what you may have seen in the news?
No, I mean, I'm one of those persons that I don't want to say skeptical of what I see on TV, but I also don't necessarily believe 100% of what's on the news or TV. I just kind of stay away from that.
Okay. There was a question in the questionnaire that reads, "Have you ever talked about George Floyd's death with your family, friends, or coworkers, or discussed it online, for example, on social media?" It appears that you checked the box no, but then scribbled over that and then checked yes, and you wrote, "We discussed mostly about the riots that took place after, but didn't about his death. Conversations were with immediate family." Would that still be accurate? I mean,
yeah, and I think I crossed it off when it's like talking on social media. I
Okay.
didn't talk about it on social media, so when I read that, and yeah, we, in passing, we have brief conversations. We're not a very political family that talk about politics when we get together. I mean, we're just more like, let's get out, have some fun, have some beers, have a good time. We did, just with living in Minneapolis, not living in the surrounding area of Minneapolis, but living in Minnesota, we talked about the aftermath and what happened, and it was kind of hard not to talk about.
right. Yeah, and that's fair. Again, everybody is entitled to their opinion, right? And that's not our job here, is to question the validity of your opinion. Our job is to determine, if you have formed an opinion, can you take that opinion and set it aside and fairly and impartially judge this case based on the evidence that you see in court? Can you do that?
Yes.
You were asked a question about whether you believe the community has been negatively or positively affected by any of the protests that have taken place in the Twin Cities area since George Floyd's death. And you wrote, yes, negatively. Can you explain that?
Yes, I personally don't live in Minneapolis, but if I was speaking directly to the community within Minneapolis, I think it would be hard to say that what's happened over the summer positively influenced or was good for Minneapolis. With everything that was going on for whatever reason, I don't think that's positive. So I did definitely think that affected it negatively. I also look at it from a business owner's standpoint, where it may have affected a lot of different business owners. Mm-hmm. I mean, obviously, if everybody saw what was happening, I don't think that was necessarily a positive thing, in my opinion.
So let me, if you don't mind, let me just kind of explore this with you a little bit. Is there anything positive that came out of it, in your opinion?
I don't believe so.
Okay. So there, I think that if I go back here, the question is about the protests, right? Would you agree that there is a difference, or maybe would you agree or disagree? There's a difference between protests and rioting.
100% difference between protesting and rioting.
Right. And obviously, would you agree? Well, let me ask you: would you agree that there were both protests and riots that occurred after Mr. Floyd's death?
I would agree with that statement.
All right. The question was asking you about the protests, and I know that people kind of jumped to the riots. So, in terms of the protests, is there anything positive that came out of?
I believe that if everybody has a right to protest for what they believe in, and so if we're looking at just that context of that part of it, yes, I mean, if the protests were, if it was positive for certain people that have certain beliefs,
Okay.
I believe that was positive. I do, on the other hand, think they may have gotten hijacked from the rioting, where it went from a peaceful protest to not so peaceful, and I'm all for anybody protesting what they believe in. I mean, that's our right as Americans.
Okay. Well, again, without referencing what your specific business is, but it's fair to say you're a business owner, right?
That's correct.
And I would assume that your business was affected by some of the COVID-19 restrictions and shutdowns?
That is correct.
Okay. And were you familiar with any of the protests associated with the governor's orders as they pertain to businesses and restaurants?
Somewhat. I don't know if it was televised as much or if it was talked about as much.
Did you participate in any of those protests?
No, not at all.
Okay. There was a page on here that had a series of statements labeled A through L. And they're just sort of these blanket statements, and then you were asked to kind of rank from 1 to 5 the level of your agreement or disagreement with that statement. Again, I don't expect you to remember all of them or what your answers were, but there's a couple of them I need to ask you about.
Okay.
The statement is made, discrimination is not as bad as the media makes it out to be, and you somewhat agreed with that statement. Can you explain your thinking in that answer?
Can you repeat that?
Sure. Discrimination is not as bad as the media makes it out to be.
I don't believe it is. I think the media tends to hype things tremendously on some aspects. in my personal life, I have friends of all backgrounds, and I don't see it. And, I'm just going based on what's in my life. And I do believe the media does tend to hype things, whether it's about discrimination or any aspect of things.
Or even potentially COVID-19 restrictions?
COVID-19, a lot of different things. I think, and I'm not saying they do that for everything. I'm not a conspiracy theorist by any means whatsoever. I do believe sometimes in some aspects of the media, it is overhyped when it doesn't need to be.
Okay. So would that, the next question was, blacks and other minorities do not receive equal treatment as whites in the criminal justice system, and you somewhat disagreed with that. Is it the same rationale, or, it doesn't involve the media, but why would you somewhat disagree with that proposition?
I've never really been involved with the police. I don't personally see it. I don't think that's necessarily a 100% honest statement.
Okay, fair enough. Now, the one question I had was, this one statement reads, I support defunding the Minneapolis Police Department, and you strongly agreed with that.
I should have been strongly disagreed.
Okay, so that was an error on your part?
That was an error. I strongly disagree.
Okay. One question reads, because law enforcement officers have such dangerous jobs, it is not right to second guess decisions they make while on duty, and you somewhat disagreed with that. Can you explain that?
Can you repeat that again?
I sure can. Because law enforcement officers have such dangerous jobs, it is not right to second guess decisions they make while on duty.
I somewhat disagree with that, because I feel just because they're police officers, they should be held to a high standard, especially with their training that they've had. I think just because you have a badge doesn't give you, free pass on anything. And if there are certain instances where they should be questioned or should be looked into, I think that's a fair and reasonable statement.
Okay.
I don't think it's just be whatever decision it is, they're 100% accurate.
Okay. Now, you were asked a couple of questions about both the Black Lives Matter movement and the Blue Lives Matter movement. With respect to Black Lives Matter, the question reads, how favorable or unfavorable are you about Black Lives Matter? And you checked the box that says somewhat unfavorable, and you wrote, I feel the movement has good intentions, but has been involved in too much destruction in our city. Can you just explain that a little bit more?
I wrote that because, and again, I never read their mission statement. I understand their movement. I feel like it may have been hijacked again. I'm sorry to use that word again, but and maybe they intended to be peaceful in the beginning, but I feel like it's kind of moved away from that. Maybe not the entire movement or entire organization, but I also feel like, yes, Black Lives Matter, White Lives Matter, all lives matter, Hispanic lives matter. I feel like all lives matter.
Okay. I just have to ask, do you attribute all of the property destruction to Black Lives Matter movement or organization?
No, I have no factual basis on saying that or stating that, but you can't go through the city with seeing the initials. I think that's a fair statement, but do I attribute that movement with the destruction? No.
Okay. All right. With respect to Blue Lives Matter, you wrote somewhat favorable or neutral. You checked both boxes, and you wrote, I feel it is a tough job and we should have a level of respect for what law enforcement does every day. So, can you explain that a little bit more?
Well, I put somewhat favorable only because if Blue Lives Matter is talking about the police officer, I do respect the men and women that put on the uniform, put on the badge, kiss their kids, kiss their spouse goodbye every single day, and put themselves in harm's way. Maybe not every day, but that's the job they signed up for. And I've obviously put neutral because I don't know what the actual movement stands for. If it's a movement, if it's an organization, I haven't read the mission statement. I'm not really sure what the movement is.
Okay.
But that's where I put that down and then wrote that behind it.
Okay. Now, you did serve on a jury you used to live in California, correct?
That's correct.
And you served on a jury there.
That's correct.
So I'm not asking you to tell us what the verdict was, okay? So let's get that out of the way. Did you have a favorable experience in that?
Yeah.
Serving on that jury?
I wouldn't say favorable or unfavorable. I was willing to do it. But yeah, it was just fine.
Okay. Did you ultimately deliberate with the jury?
We did.
And did you ultimately reach a verdict, not knowing what the verdict was? I don't want to.
We did.
Okay. Now, so you have some experience in serving on a jury,
That is correct.
right? And so you're familiar with the process of deliberations.
I am.
Is there anything about that previous jury service that you think would somehow affect your ability to serve on this jury?
Not at all.
You're not going to take what you learned in that situation in a different state and try to apply it here, right?
No, because you're comparing apples to oranges, especially in this case.
So let me ask you, I forgot to ask you a couple follow-up questions. In this case, you will hear testimony, I expect, from numerous law enforcement officers. I expect that you will hear testimony from numerous civilian witnesses and other people who investigations uncovered. Okay? Would you hold police officers' testimony? Would you determine it to be more truthful simply by virtue of the fact that they wear a badge?
No.
Would you, if you have a police officer who sees something and a citizen who sees that same thing, are you willing to treat those testimonies as equal?
I would.
Would you give any more credibility to the police officer simply by virtue of the fact he's a police officer?
No. I think for me, it would be, how it's said, and if they're speaking with conviction, if they're speaking with more confidence, you'd have to base that judgment, once we're sitting here, if I'm sitting here.
Okay. All right. And one other question, general, I guess, question I forgot to ask you was, if you believe, if the judge instructs you on the law, and you believe the law should be different, or you think that what the judge told you is wrong, are you able to follow the law as the judge gives it, even if you think it should be different, or you think he's wrong?
Yes, I'd be able to follow the law.
All right. The last question was, do you want to serve as a juror on this case? And you checked the box, not sure. And you wrote about your concerns about, the lack of anonymity or the fact that your name could become public. Do you still have those concerns?
I don't have those concerns anymore.
Okay. And so, are you willing to serve on this jury?
Yes.
Is there anything that you think I should know that would affect your impartiality or anything of that nature?
No.
If I may have a moment here.
will pass for cause.
Mr. Swisher.
Thank you, Your Honor. Juror number 38. Good morning.
Good morning.
It's not afternoon. So to clarify one of the questions that you answered on the questionnaire regarding police in your community, the question was, police in my community make me feel safe, and you said strongly disagree. At least that's what my notes. Might that have been an error?
It might have been an error. I might have been reading it wrong.
Okay. And so what would your answer be in terms of how police in your community make you feel? Do they make you feel safe?
They make me feel safe, yes.
Would you strongly agree with that answer?
I think that's a fair statement.
Okay. And you do strongly disagree with the defunding the Minneapolis Police Department, is that right?
That is correct.
Can you tell me why?
I feel like that would... Let me back up. I feel like, you know, police are hired to make the streets safe, make people safe, make people feel comfortable, and I think defunding that would kind of set a bad example, not necessarily for police, but for people that are in need. And if somebody is called upon and call the police, and if there's, because of limited funding, there's limited police officers, and the time to get to the call takes longer than it should. I feel like some people would be negatively affected by that, and I just wouldn't think that would be fair, and I don't think that I'd want that for any family or any business or anybody.
And so if you needed the police, you would like to know that you could pick up the phone, call, and that they would be available to help.
Yes.
And you would rely on them to do that?
Yes, depending on the situation, but yes.
Generally speaking?
Yes.
Okay. It sounds like you have a strong respect for law enforcement. Is that fair?
I think that's a fair statement.
Have you ever had any negative interactions with law enforcement?
I have not.
Or any friends or close friends or family members have a particularly negative experience? When you moved, when you moved from California to Minnesota, did they tell you about the weather we have here before you made that decision?
Well, unfortunately, I married a Minnesota girl.
That happens to a lot of people. Yeah. So here you are. When you were new, let's say a hypothetical situation, you're in downtown Minneapolis and you're not, sure which way to go to get to the IDS center, right?
Right.
And you're walking down the street and you're looking for directions, and you see a police officer, and he tells you the IDS center is over here, and you see a bystander, and they say actually it's in the opposite direction. Which way do you think you'd walk?
I would take both into consideration, I guess.
I wouldn't
ask two people. I guess to answer your question, I wouldn't ask two people. I would have no problem asking the bystander if that's the first person there. Mm-hmm. I don't think it's the job of a police officer to navigate people. Sure. So I probably would have just asked the bystander.
But if the police officer told you, no, go that way, and the bystander said, no, it's over there, do you believe that you would evaluate, I guess, both of those directions equally?
Well, it depends if I'm alone or with my wife. I would just ask my wife.
Okay. But your wife isn't there, and you're by yourself, and you're looking for direction. Whose direction are you going to follow?
If I have to choose,
yes.
The police officer, I guess. It's a tough question to answer because, if he's the first one I asked, I would go that way. If I'm halfway down and I don't think it's right, I'd go back the other way.
The point of the question, which I'm sure you surmise, is that you said when questioned by counsel that you would credit the testimony of a police officer the same as any other witness. And, you know, you're under oath and you're answering the questions, I'm assuming honestly and as best you can. But I need you to really think about that. You know, given what you stated are some fairly strongly held beliefs about police officers. It sounds like you believe that police officers don't get as much respect as they deserve. Was that right?
I don't think I used those words.
It was on the survey. I mean, the
Yeah.
questionnaire.
I mean, I think what I'm trying to say is, you know, they made a choice to go into that profession, and I feel that profession has, you know, its ups and downs, and it has its, I'm trying to think of the right word for it, safety issues at some point, and so I respect that. Just like I strongly respect anybody that decides to go into the military. You know, I have respect for that. So I wouldn't say I have a strong belief that a police officers are going to be right all the time. I'm more answered that as I respect the police. You know, I respect people who serve the country.
And really that does get to the point of the question. Believe me, I'm not challenging whether or not it's right to have a strong respect for police officers. What I'm asking you to do is, given those beliefs that you have, you know, really evaluate whether you could fairly, you know, evaluate a case. And for example, if a bystander was saying something and a police officer was saying the opposite, to be able to give both of those witnesses the same degree of credibility. And, you know, can you assure us, and you be sure that you would be able to do that?
Yes, absolutely.
I wanted to follow up a little bit about the, you know, you did express some concern about serving as a juror in this case because of the high-profile nature. And I think that what you said was that it could possibly put your, you know, it could possibly put your family in harm or in harm's way. Do you remember saying that?
Yeah.
Can you just tell me what harm do you think, what specifically were you thinking about in terms of harm as a result of publicity?
Well, I would just, you know, when I put that down, I didn't know we would be anonymous. And with, you know, the social media, the information that can be out there quickly, rapidly, and extensively, just didn't want anything coming back to myself or my family. I don't necessarily think it would be like severe violence, just any disruption with the business, with the family, that sort of thing.
So if I'm to understand, you wouldn't fear violence, it was more just with the public nature of things?
You're right, the public perception, I guess, not necessarily the violence.
Do you think that you would have more of a concern during the trial or after the trial?
Definitely not during the trial, potentially after. And again, I wrote that not knowing how this would all play out. It would definitely be, you know, after, if at all.
Can you think of a circumstance after a trial in which you think that, you know, perhaps the level of danger would be greater?
No, I would look at it as if somebody knew that I was, you know, sat on the jury, if I did sit on the jury, to be more disruptive than anything else. You know, it's like getting a negative review on Amazon, if you will. I know it's a bad example, but that's just what I can think of right now.
That someone might have a negative opinion of you just for having sat on the jury.
Yeah.
And do you think that the opinion, I suppose, would have anything to do with what verdict you might render? So, for example, would you be more concerned if you were to render a not guilty verdict in this case versus a guilty verdict?
No, I don't think that would be relevant at all. I think it would just be the fact that sitting on it, the jury.
you indicated that you did discuss with family members mostly about the riots that took place after George Floyd's death. Is that right?
That's correct.
Can you just give me a little more detail on what you would have discussed with family members and what views were expressed?
Well, for example, just sitting down and seeing, like, have you guys seen what's happening to downtown Minneapolis? Can you believe it? And just the extent of it, and being here and watching this, you don't see that very often. So, just the initial reaction was kind of like the shock, like what's happening, and that was it. We don't, again, we don't spend a lot of time talking about it, or we didn't previously. It was just more of a 30, 42-minute second conversation.
And I'm assuming that the conversation would have taken place over a series of days as things didn't calm down right away.
Yeah.
Did you avoid going into the city of Minneapolis during that time?
Well, during when it was happening?
Yes.
Oh, yes.
And did you watch actual live footage of this happening on TV?
I've seen live footage. Yes, we watch it. We wouldn't, come home and sit and watch it for hours on end. But yes, we could. Would definitely seen it and watched it.
From what you were able to see and observe, were you able to determine who or what groups were responsible for the riots and the damage?
No, I have nothing to base it on. It was, this group or that group. It was just more of it happening, if anything else.
I want to then just turn back. You were asked opinions about the group Black Lives Matter. Council asked you some follow-up questions related to that. And when you were talking about the group and the somewhat unfavorable view you had, you said that you feel the movement has good intentions, but has been involved in too much destruction in our city. And that second part of it has been involved in too much destruction in our city. Can you please explain what you meant by that, specific destruction?
Well, I just think with the rioting or all the burning down of, I don't say burning down, that's the wrong choice of words, but the vandalism of the city, and seeing the letters BLM, whether that organization did it or not, it was kind of hard not to not see those. So not accusing that organization of actually doing it, but it was hard not to see those letters. So that's why it was like somewhat unfavorable if they were involved in it, or if any faction of that group was involved in it. I don't think that's necessarily a positive way to portray what you're trying to come across, or portray your what your philosophy is and what your goal is for that movement.
All right. Thank you very much, sir. I appreciate the answers you've given us today.
Okay. Thank you.
State strikes.
All right, thank you. Thank you, sir. You are being excused from this jury,
Okay.
and so the deputy will collect some things for you. So this also ends your jury service for this term as well, so you don't have to worry about reporting for anything else.
Thank you.
All right, thank you. Next is approval, right? All right, it does appear that it's about a couple minutes to noon. It's a couple minutes till noon. The next juror has not gone through the group instructions, as opposed to talking to one this close to the lunch hour. My proposal, and since we already struck one for cause, we only have if we put this juror off to the afternoon, we'd only have 4 this afternoon. So my inclination is to recess for lunch, come back at 1:15. The other jurors are scheduled to arrive by 1, and with the jury orientation, I think it's, assuming everybody's on time, we could start at 1:15. So let's shoot for that. If we have some stragglers who we need to postpone past 1:15, but let's shoot for that as when we reconvene 1:15, and we'll tell this juror that we have lunch for him, and that we'll do it at 1:15. All right, thank you. Well, good afternoon, everyone. First, can you all hear me? If not, we'll provide some hearing assistance devices. Okay, I'm getting a lot of nods and thumbs up, so I think we're good. All right, my name is Pete Cahill, and I'm one of the judges of the district court, and you have been summoned as potential jurors in the case of State of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before an impartial judge and an impartial jury. In order to make sure that the jurors who are selected are impartial, the law provides that the court and the attorneys for the parties may ask questions to all prospective jurors, which must be answered under oath. First, thank you for filling out the questionnaire that was mailed to you. We appreciate that. Your contribution to the important and serious matter at hand is best assured by continuing to provide full and complete answers to the questions that you'll be asked today. These questions will follow up on issues from the questionnaire and probably other topics. Now, after the questioning is over, the attorneys will have the right to excuse some of you from service on this jury, and I may excuse others of you for what is called cause. In either case, it does not mean that you are not a fair person, and you should not take offense in being excused. I also ask that you not take any offense at any question you may be asked. We must pry, at least to some extent, in order to explore opinions you might hold and to hear about experiences you have had that might affect your ability to serve in this case. Now, the defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree. In the normal course of the trial, charges might be added to or subtracted from these charges, but those are the charges as it stands. To the charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. And I'd now like to have the parties introduce themselves to you to see if anybody recognizes anybody in the courtroom. First, on behalf of the state.
Thank you, Your Honor. Good morning. My name is Steve Swisher, representing the state of Minnesota.
Hello, my name is Christina Marinakis, and I'm assisting with the prosecution.
Hello, my name is Keith Ellison, and I'm with the state.
I'm Joshua Larson. I'm also with the state. Thank you.
And for the defense, Mr. Nelson.
Good afternoon. My name is Eric Nelson. This is my client, Derek Chauvin, my assistant, Amy Voss.
Thank you. Anybody recognize anybody who's been introduced or anybody else in the courtroom? Okay. I'd also ask other attorneys might be here today or other days during the trial. And so I would ask if anyone knows Matthew Frank, Aaron Eldridge, Jerry Blackwell, or anyone else who works for the Office of the Minnesota Attorney General. All right, I've seen a lot of head shakes. No? No. Raise your hand if the answer is yes. Does anyone know or acquainted with anybody from Mr. Nelson's firm? Okay, no hands. And you have been given a copy of a list of potential witnesses. Please review it if you have not done so already. Before you are questioned individually, you'll be asked if you recognize anybody who is on that list. Now, one of the things the attorneys may not do during jury selection is to instruct you on the law. But I want you to be aware of some of the basic concepts that apply in every criminal case so that you may keep them in mind as you answer the court's and attorneys' questions. So I'll instruct you as follows. First, the charges against the defendant are not evidence, and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant throughout the trial, unless and until he has been proven guilty beyond a reasonable doubt according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. Now, if you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect, but in determining believability and weight of testimony, jurors may take into consideration the witness's interest or lack of interest in the outcome of the case, relationship to the parties, ability and opportunity to know, remember, and relate the facts, their manner, their age and experience, their frankness and sincerity, or the lack thereof, the reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, and any other factors that bear on believability and weight. If on this jury, you should rely in the last analysis upon your own experience, good judgment, and common sense. Now, there are certain things you should not do during jury selection. You are not investigators. You are not to go out to do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved, the lawyers, the witnesses, or even spectators. Do not be offended if the attorneys, parties, or witnesses do not speak to you. They know that it would be improper to contact you except through the normal jury selection process, and normally they will confine themselves to a brief greeting. During the selection process, your family and friends will be curious as to what you are doing. You may tell them you are on a panel of potential jurors in a criminal case, and that is all you should tell them. And since that is all you should tell family and friends, that is all you should tell the general public. So, during these proceedings, please refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on this trial. You may access such social media tools, but please do not publish any information about the case or your thoughts about the case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about the case. And above all, do not talk at all to anyone involved in it. Now, because of the nature of the charges, this case is receiving media coverage. Do not read about this case in the newspapers or online, and do not listen to news about it on radio or television. This trial, including jury selection, is being televised, but no video of you or any other juror will be taken at any time, now or during trial if you are selected. Also, your name will not be used in the courtroom. You will only be referred to by your random number. We aren't being disrespectful, it's just to protect your privacy. The audio of anything you say will be broadcast, unless we need to discuss something deeply personal or extremely sensitive or embarrassing, or would tend to identify you too clearly. In that case, I will specifically order that the audio not be broadcast outside this courtroom. In that case, you will still have to answer questions that will be on the record, but without that audio or video broadcast. Now, with the exception of juror number 39, we'll have you wait in another courtroom until it is your turn to be questioned, and you'll go with a deputy to be escorted back there. Just a reminder, whether you're in that courtroom or this courtroom, we are using COVID prevention measures, so feel free to use all the wipes that are available around all the various courtrooms, and also please wear a mask and follow social distancing guidelines. I have taken my mask off to be more clear during these instructions, since I am a good distance away from you. But when we start individual selection, I will take my mask, or my mask will be back on. So with that, juror number 39, you may remain, and the remaining jurors, please go with the deputy.
All right, juror 39, if you could come up here. And if you have a seat right next to me. All right, just for the record, I have my mask back on. We have plexiglass between us, which is sufficient in and of itself. So if you would like to remove your mask, you should feel free to do so.
Okay.
If you're more comfortable with it on, obviously keep it on.
Okay.
In either case, we're going to ask you to pull close to the microphone so that you can be heard pretty well. Okay?
Okay.
Now, before I turn it over to the attorneys, I have a couple things to go over with you. First of all, I'm going to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do. I will.
All right, thank you. First of all, you filled out a questionnaire, and thank you for taking the time to do that. It's very helpful for the attorneys and myself. Is everything that you put in that questionnaire true?
Yes.
Now, it's real common, since that was months ago,
Yes.
that in reflection you might think there's things you need to add or even change because you realize, oh, I should have put that in the questionnaire. So feel free to volunteer that when it comes up.
Okay.
You don't get in trouble, because we realize even some of the opinions you might have put in there may have evolved over time.
Right.
So it's not a problem if it's different. The only thing we ask for is your honest opinion.
Okay.
As you sit here right now, are there any major changes you can think of?
No.
Okay. The attorneys will be going through specific questions, and I'm sure you didn't keep a copy of your questionnaire,
Right.
so they might read the answers to you to kind of refresh your memory.
Yeah.
And then if you have a different answer, then feel free.
Okay.
The questionnaire did advise you not to read any articles and to avoid the media about this case. But again, we recognize that was months ago, and I'm sure you did your best efforts to avoid that.
Yes.
Sometimes inadvertently you might see a headline, or you might be talking to a friend and they start talking about it.
Right.
And since we told you don't tell anybody you're going to be a potential juror, you can't really stop them.
Yeah, that's right.
So it kind of puts you in a tough spot. Did anything like that happen such that you learned some more information about this case between now and as you sit here, or between the questionnaire and as you sit here right now?
The only thing I can think of is yesterday my wife told me she knew how many jurors had been selected.
Okay. I don't think that's really going to prejudice you here, so.
Okay.
Um,
And she didn't tell me.
okay.
Yeah.
All right. Anything else that you remember, either pretrial matters about the parties or anything like
No.
that? Okay.
No.
All right. You were given that long list of witnesses. Did you recognize anybody on it?
No, I didn't.
Okay. Now, as I mentioned, you put in the questionnaire what you knew about the case, and I think just about everybody knew something, some more than others.
Of course.
And there are various opinions that you've given based on what you know. The point of all that was so that the lawyers kind of knew the baseline to work from, but also as a reminder that perfectly fine that you heard things, perfectly fine that you have formed opinions about the case or the people involved.
Yes.
The question becomes, can you put all that aside? Put aside what you know, what you've heard outside the courtroom, put aside the opinions you might have formed, and decide this case just on the evidence and the law that I give you.
Yes, I believe I can.
Okay. Do you think you could be fair and impartial?
Yes, I do.
All right. Now, the length of trial we estimate is about 4 weeks, starting March 29th. For example, if you're picked on this jury, you'd be released to be out and about, do what you want, work if you want, not work.
Right.
But we would expect you back on March 29th, and then the next 4 weeks would be consumed with the trial. Can you make that work?
Absolutely, yes.
All right, great. Any questions for me before I turn it over to the lawyers?
None.
All right, thank you. Regarding juror number 39, Mr. Nelson, you may inquire.
Good afternoon, sir.
Good afternoon.
Thank you for your time here today and for coming in and your patience as we work through all of this. So I'm going to ask you a series of just kind of general questions to get to know you a little bit better, and then I'm going to circle back and talk about your questionnaire.
Okay.
I understand it's been quite some time since you've written these responses.
Yeah.
I'm assuming that you don't remember every single thing you wrote.
No, I don't.
All right. So as I go through them, I may read some parts to you.
Please do.
All right. And I'm not trying to trick you or
No,
anything.
I realize.
We're certainly trying to just see if you're the right person for this jury.
Yes.
Okay. So if I were to meet you in some social situation, a party, an event, and we engaged in conversation, I walk away from that conversation, what are a couple things about yourself that you would want to communicate to me, you'd want me to know about you?
I guess that I am an open person, open to different opinions.
Okay.
Not in any way aggressive person.
Okay.
I guess.
All right. Do you have any special interests, hobbies, things like that you do?
Music is my biggest hobby.
Okay. You're a musician yourself?
Yeah, I was in my past life, yes.
Okay. But still in the collection and things of that nature, right? As I recall?
I'm pretty much just a listener of music right now.
Okay. So at some point you received a summons to jury duty. It would have been a page or two long, telling you that you were a juror. When you got that notice, what was your first reaction to that notice?
I believe I shouted at my wife. Come here.
Okay.
That's what
All right.
Yeah.
And then was that because you were upset or angry or because you couldn't believe it?
I couldn't believe it.
Okay.
Yes.
All right.
I couldn't believe it.
Did you get the questionnaire with that same notice?
No, not that I recall. I think that came later.
Okay. And then how about when you got the questionnaire and it said that you were going to be a potential juror in this particular case?
Oh, maybe I'm becoming confused because
Okay.
it's when I learned that it was this case
Gotcha.
that I yelled
Gotcha.
at my wife to come. So could you repeat the question?
Sure. I think you've answered it.
Oh, okay.
You know,
Yeah.
I was trying to gauge your reaction to learning that you were going to be a juror in this case.
Yes.
That's what it was. That's when you yelled at your wife. Or yelled for her.
For her to come.
Yeah, not at her.
I wasn't yelling at her, no.
Right. Okay. When you learned that you were a potential juror in this case, did it cause you any concern for your personal safety?
It caused my wife concern?
Okay.
No, I don't think it did cause concern.
For you?
I felt a real heavy sense of responsibility.
Okay.
It wasn't really a sense of danger, but just the responsibility of it was heavy.
Sure. But your wife did have some concern?
Yes. Yes.
Where do you think that concern, why do you think she was concerned?
I think she thought I might become a target of something.
Okay. Like from in the context of harassment or physical violence?
I didn't really ask her specifically what she was afraid of, but she was definitely afraid.
Okay.
Yeah.
Did you guys have like conversations about it?
I tried not to.
Okay.
As much as I could.
Right. Was that because you were instructed not to talk about it, or because?
Right. Yes.
Okay. Gotcha.
Yeah.
I mean, and you know, it's your wife, right?
It's my wife. Yes.
And fair to say you had I mean, you're not in trouble if you talk to your wife about your concerns or any concerns she might have.
That's right. Had the first line of that letter said, "Don't tell anyone what's in this letter," she probably wouldn't have known.
Okay.
But the problem was that sentence was later in the letter, as I recall. And by the time I'd gotten there, I'd already told her.
Gotcha. So it seems to me that there are things you hide from your wife.
Well, I don't know about that.
All right. So how about when you came down to court? Today's your first day here, right?
Yes.
Right. And you saw the current status of the government center.
Yes.
What was your reaction to that? Like, what did you think?
I thought it was perfectly reasonable and it was the right decision.
Did it help you to feel more comfortable so that you could reassure your wife about your safety during this process?
It's what I expected. It was a little more than I expected, but it didn't change my mind about anything.
Okay. How about when the judge just kind of told you about anonymity and how we're trying to protect your anonymity? Does that help?
Yes, I think that would be yes, it does help.
Okay. And in terms of, at some point in the future, it's very possible that your name would be released publicly.
I totally understand that, yeah.
Okay. And are you comfortable with that?
Yes,
okay.
I am.
All right. So in your personal or professional life, can you think of a time where you have been called upon to resolve a dispute or a conflict between two people?
Let's see. I have never been a supervisor at work.
Okay.
So
Well, how about like two friends? They get in an argument and they're like, hey, juror number 39, come over here and help us get to the bottom of this.
Last year I was involved in the Hennepin emergency response, and I worked in a situation where homeless people were in hotels, and different times the guests at the hotel would there would be a confrontation.
Okay. So
with staff.
With staff?
Yeah.
Okay. So in that context, and that I think that's an insightful response. In that context, what tools or efforts would you do to resolve that would you utilize to resolve that conflict?
I would try to bear the brunt of the person's anger and remove the staff member, put myself between that person and the staff member.
So these were more physical confrontations?
Not physical, no.
Okay.
No.
But like verbal?
Verbal, yeah.
Okay. So you would kind of just put yourself in the middle and...
I would try to, yeah. I try to take responsibility.
Okay. In your personal life, have you ever, or can you think of a situation where you have had to take two sides of a story and decide which person is telling the truth?
Yes.
Okay.
Yeah.
And what tools do you bring to that analysis? How do you decide, is this person telling the truth versus this person?
I try not to take sides. I try to get to know both people, and sometimes I'll never know. I'll never know who's right.
So that's an interesting statement. Are you comfortable with not ever knowing who's right?
Sometimes I have to be.
Okay.
In the situation I'm thinking of, I just have to be.
Okay. Now, in terms of, again, you're trying to resolve this dispute, right? Or excuse me, trying to determine who's telling you the truth. You said you talked to both sides, listen to both sides of the
Yes.
story, get to know the individuals, get basically the facts of what happened, right? What each person is saying happened.
Yes.
Would there be other things that you could use or that you would consider as important in helping you to decide who is telling the truth?
I would say in that situation, if one person is withholding information from me, then I'm less likely to believe their story.
So when you say withholding information, would you view value or gathering other information an important part of that process? Perhaps if I were to use the word evidence?
Yes. In the case I'm thinking of, that these things happened 30, 40 years ago, so
Yeah.
there isn't really that much evidence to go on
Sure.
in these situations.
Okay. But would you view that as if there's evidence supporting one?
Oh, I have asked for evidence. Yeah. If there was evidence, that would be important.
Okay. Would you consider talking to other people who may have been there or witnessed it themselves, whatever this situation is?
Because this happened when I was a child, I really don't know those people anymore.
Okay. All right. I guess, just in general, if you were a juror member, it's getting to be a long day. If you were a jury member here in this case, right?
Mhm.
Evidence will be introduced into this trial.
Yes.
Right? And you may take one piece of evidence and assign it a particular meaning.
Yes.
And that meaning may be very important to your analysis of this case, right?
Yes.
But one of your fellow jurors may look at that same piece of evidence in a completely different way than you
Okay.
did, right? And ascribe it a completely different meaning.
Okay.
It's a hypothetical,
Yes.
right? So how could you envision resolving that conflict? You think some piece of evidence is really important, but somebody else doesn't.
The same piece of evidence.
Exact same.
We're
piece
looking
of-
at the same thing and seeing two completely different things.
Right.
At some point, I just have to respect his or her viewpoint.
Would you automatically give up your viewpoint and just, in order to build consensus, would you just abandon your belief it was important?
No.
Okay. Because ultimately you understand that any jury decision has to be unanimous. You understand that?
Yes, I do understand that.
And that, the concern or the question that we ultimately have for jurors is, are you going to participate in the process, right? And are you just simply going to agree for purposes of agreement, or are you willing to stick by your guns?
No, absolutely the latter.
Okay.
Absolutely.
All right. But would you be willing to re-examine your analysis of that hypothetical piece of evidence in order to try to see the perspective of the other juror?
Yeah, I don't think there's a question about that.
Okay.
You have no choice, right?
Right.
Right. So,
Can you think of a situation in your life where you were 100% convinced that you were right, but then suddenly something came up and you realized you were wrong?
Um, hmm. I'm trying to think of something, but
And it's,
blanking out.
yeah, it's okay. I mean, do you think it's possible that you've had that experience in life, maybe without a concrete
I think it's
example?
hard to go through life without having that experience. I'm just having a hard time thinking of one.
Sure. Well, let me just put it in the abstract rather than having a concrete specific example in mind. If you were to be convinced of something, absolutely, and it later turned out you were wrong, how do you think you would respond to that?
You know, just popped in my mind was Woody Allen.
Oh.
I used to love Woody Allen.
Okay.
Just thought he was perfect. And obviously he's not to me now, so. But it doesn't, that's not even a good example because that doesn't mean his films weren't good. Jeez. Could you repeat the question again?
Sure. I guess I'll just, again, just rather than trying to focus on a specific example.
Okay.
You acknowledge that at some point in your life, you probably had a very firm belief in something and it later was proven wrong. How do you feel about that? Like, you know, when that happens, are you the kind of person that says, oh, well, no big deal? Or are you the person that tries to learn from that mistake and apply it to future decision makings?
I hope I'm the person who could do that.
You strike me as someone who's quite reflective. And I appreciate that, right? I mean, I really appreciate the thoughtful responses that you've given us both in the questionnaire and here today. So, and I'm not, you know, I'm not making light of that. I just want you to know that. So, let me ask you some questions about your questionnaire, if that's okay?
Please do.
Okay. I'll try to, it'll be a little less esoteric and, and more concrete. One question I had is, what is the Hennepin Emergency Response? Is that a volunteer organization or is that?
That was Hennepin County.
I apologize. You're, yep, we're going to move on from there.
Okay.
The first question in the questionnaire asked you to write down what you remembered hearing about in the media about this case.
Yes.
Okay. And you wrote a lengthy paragraph based on some of your recollections or what you had seen in the media. Okay?
Yeah.
This whole thing kind of started with a Facebook video. You're aware of that? I mean, in terms of how it became so publicized?
Yeah, a video. I didn't know it was a Facebook video.
Okay.
Right.
So we'll talk a lot about a video or the video. You're aware that a bystander took a video of the arrest of Mr. Floyd?
Yes.
Okay. And the bystander circulated that video through social media. It went viral and hit the news, right?
Yes.
Okay. Is the video, you said that you've watched a video of Mr. Floyd's death on the news or internet 2 to 3 times. That's what you estimated back when you filled this out.
Sounds right.
And what I want to make sure we're talking about the same video.
Yes. Yeah.
That's why I'm asking these questions. Was the video you saw, did it appear to come from a bystander to the arrest, or was it more like body-worn cameras of a police officer?
It was a bystander.
Okay.
Yeah.
And did you see that video simply in the news, like in short clips, or did you go on the internet and look up, or some social media, and watch a longer version of that video?
No, it was in the news, but I believe I showed that to my wife when she came home. I
Okay.
played the news for her.
Right. And so, I mean, I guess the question is, have you, the parts of the video that you watched, I think we're talking about the same video, but the parts that you watched were 30-second news clips or a minute news clips or less?
Yeah, if that, yeah.
If that, right. And you saw those on the news a couple of times,
Yes.
right? Obviously, this became a major part of the news cycle for some time, right?
Yeah.
Yep. And you would and it sparked conversations, obviously, with you and your wife, but also with your friends and family members
Yeah.
and things of that nature too, right?
Yes.
And you were asked about, a couple of questions about the opinions that you held,
Yes.
what you discussed with your family and friends, and your opinions of Mr. Chauvin as well as Mr. Floyd. Do you recall those questions generally being asked?
Generally, I don't remember about Mr. Floyd, but
Okay. So let me say first that your opinions are your opinions, right? You are entitled to have your opinions.
okay.
Okay?
Yeah.
And I don't mean to question your right to have the opinions,
Right.
but ultimately what we need to know is, will those opinions have an impact on your ability to serve as a juror? Does that make sense to you?
Yeah.
Okay. And whether or not you can set aside your opinions and judge this case on the evidence that's presented. Do you understand that?
Yes.
And you can agree to do that, do you think?
Yes.
Okay. Great.
Yeah.
So I got to ask you about a couple of your opinions.
Okay.
The question read, from what you have seen, read, or heard, do you have a general impression of the defendant? And it gave you some check the box options of very negative, somewhat negative, neutral, somewhat positive, or very positive, or other.
Uh-huh.
And you check the box very negative.
Yes.
Okay? And they asked to explain why, you wrote, I base my feelings on images of the incident that were filmed by a bystander. What I saw were the people who treated a citizen as an enemy combatant worse than an enemy combatant.
Yes.
Okay. Can you, what do you mean by that?
My reaction when I saw the video was, it reminded me of like a war scene, like an image from a war. What popped into my mind was images of World War II.
Okay. And as a result of what you saw, you formed an opinion that was very negative about Mr. Chauvin.
Yes.
Okay. And then in the conversations that you had with your friends, coworkers, family members, you wrote, I have expressed the opinion that it was an outrageous incident and that the Minneapolis police need to be rethought. That in this instance, the police were behaving more like an occupying force than a police officer.
Yeah, that's what hit me. I would say.
Okay. And so I guess I have a couple follow-up questions on that. Were those thoughts specifically directed towards Mr. Chauvin?
No, I don't know Mr. Chauvin, so.
Okay. I mean, when you say an occupying force and this imagery of war and World War II, right? were you looking at it from the context of there were other officers involved, or were you sort of focused on the actions of Mr. Chauvin?
I was focused on what I perceived to be a lack of respect for life.
Okay. And I appreciate your opinion. You're not the only person who's come into this courtroom and had that same opinion. Okay? It's a very valid opinion. It's your opinion, and you're entitled to it.
Mm-hmm.
The question, though, becomes, right? You have this opinion.
Yes.
It's bad, right?
Yes.
It's so bad that you're comparing it to, or likening it to, images of war.
Yes.
Right? And so you had a very interesting answer, I thought, when in the questionnaire, when it talked about the presumption of innocence.
Okay.
And if you let me read your response to that. The questionnaire asked you, under our system of justice, defendants are presumed innocent of the criminal charges against them. Would you have any difficulty applying this principle of law? And here's what you wrote. You wrote, in a case with as much publicity as this case, it is difficult. Based upon the visual evidence I have seen, I haven't presumed the defendant is innocent. But I know I have only seen and read a small fraction of what occurred. Knowing this, I believe I can presume innocent until all the facts are presented to the jury. Okay?
Yes.
So it strikes me in your reflection on this case that you have some struggle with that concept of law, or applying that principle of law in this case, based on the opinions that you had previously formed.
I think what I'm trying to say was a video is not really much evidence.
Okay.
I mean, it's powerful. Visuals are powerful things, but it's just the tip of the iceberg of what people involved, or what everyone, what you know, what I think that's what I was trying to say. That.
Well, I mean,
just if I had to judge on just that small piece of evidence, it would be hard for me to say not guilty.
Right.
But I can acknowledge that there's evidence that would prove not guilty.
Okay. So as the criminal defendant in our country, Mr. Chauvin has no burden. He does not have to prove any evidence. He does not have to ask a single question of any witness.
That's true, yes.
He does not have to testify.
Yep.
And so you can adhere to those principles of law?
I believe I can.
So there's every juror who's come through has said, I believe I can. But the question is, you have very strong opinions, right? You know, a very negative first impression, so to speak. Can you basically clear your brain of that, a clean slate, and start from the beginning, analyze this case only on the evidence presented in the case, essentially abandoning your opinion?
Yes, I do.
Okay.
I do.
And, you know, again, I don't know what's in your heart or in your head, right? I have to take you at face value.
That's right.
And you have to do the kind of soul searching I think you've been doing to answer those questions.
Yes.
But is it hard to acknowledge that? I mean, is it hard to for you to say I can do that?
If I couldn't imagine myself saying not guilty, I wouldn't be here.
Okay.
I just wouldn't be here.
Okay. So that is one potential outcome that you could foresee from this case.
Absolutely.
Now, the questionnaire asked some questions about attending like rallies and
Yes.
protests and things like that.
Yes.
And you indicated that your wife had in fact attended a rally
Yes.
and given money to at least one organization that supports policy reform.
Yes.
Again, that you and your wife, I'm assuming, share some similar sentiments about this matter.
Yeah, that's fair to say. Yeah.
The policy reform, was it specifically the money that was donated to this organization? Was it specifically geared at policing reform, or was it other type of policy reform?
No, she predates this case.
Okay.
She's always been doing that.
Yeah.
Yeah.
Okay, and so, but your wife did at least attend one rally after these?
She did, yeah.
Okay.
Yeah.
Were you supportive of her in doing that?
Yeah, I wasn't unsupportive, no.
Right. But you didn't go yourself?
No. No, I'm in a very odd situation where I was working full-time during this time.
Okay.
So
Sure.
it wasn't even a question for me.
If you didn't have to work, would you have attended?
This particular one, I probably would have gone to this one.
Do you know, was it a
What was it?
was it a anti-police
No.
or defund the police kind of a thing?
No, it was. Oh, gosh, haven't thought of this for a while. I can't say for sure which rally it was. I don't remember.
Okay, but it wasn't. Was it about racial justice, or was it about police reform?
No, it had to do with this case somehow.
Okay. So the questionnaire had a series of questions about your personal involvement or interaction with law enforcement, and you've had some through your professional life, right?
Yeah.
And you've also had a bicycle stolen from your house, I think, and you called the police, right?
Yeah.
And actually, you said that you were very satisfied in the police response to the bike theft.
I was more than very satisfied.
They responded right away, found your bike, right?
In 10 minutes, they found my bike. My wife's bike.
Okay. Have you personally ever had any negative interaction with law enforcement?
It's funny, I remembered this today when I was a small boy. My mom was driving home from from her work, and she had a headlight out, and she got pulled over, and I hid in the wheel well, not the wheel well, where your feet go.
Oh.
And I remember the policeman shining a light in on me, and but she didn't get a ticket.
All right.
So it wasn't a scary. I mean, I must have been not even 5 years old or something. I don't know.
Gotcha. So, but other than that, memory that popped into your head today, have you ever had a negative interaction with a member of a police force?
No.
Okay.
No.
There were a series of questions, really statements, that were listed in here, and it was asked you to rank your opinion with that statement from 1 being strongly agree to 5 being strongly disagree? Do you remember that generally?
Yeah.
Okay. So I want to ask you a couple of questions about some of those opinions. So 1 states that discrimination is not as bad as the media makes it out to be. And you strongly disagreed with that. Basically saying that, I'll read the statement again.
Yeah, it's confusing, isn't it? Yeah.
Discrimination is not as bad as the media makes it out to be.
Discrimination is not as bad as the media. Okay.
And you strongly disagreed with that.
Oh, gosh. Okay. Oh, okay, I get it. Yeah, no, that's right.
Yeah.
Okay. Sorry.
It's a strange statement. I know some of these things
It's
oddly
double
worded.
negative or something.
Yeah.
Okay.
So in other words, I think the nature of the question is discrimination is real, but it's not as bad as the media makes it out to be.
And I disagreed.
Right. So you strongly disagreed.
So
that you think that discrimination is as bad as the media makes it out to be.
yeah, I guess yeah, okay.
Yep.
That's so confusing.
It's all right. Sometimes we lawyers, we like to make things a little more complicated than they need to
I'm
be.
sorry if you wrote that question.
I didn't, but that's okay.
Okay.
The next question is kind of similar to that. It reads, blacks and minorities do not receive equal treatment as whites in the criminal justice system. And you somewhat agreed with that.
Yeah, that's more of a maybe. Yeah, I don't know enough to, but I suspect that's true.
Okay. But you have no personal...
No, I can't strongly agree with that.
Okay. You have no...
Because I have no experience. I don't have the experience to tell you that.
I'm trying to take everything down, so let's try not to talk over each other. Possible.
Okay.
The next question was, police in this country treat whites and blacks equally, and you strongly disagreed with that as well.
Huh, okay. I don't know if I'd say strongly today.
Okay. I mean, do you have personal firsthand knowledge of police treating minorities differently than white people?
I'm a little surprised I said strong. I was that strong about it.
Okay. One of the statements was, I support defunding the Minneapolis Police Department, and you strongly agreed with that.
Oh, I did?
Yeah.
Oh.
And if you do...
I did at the time. Obviously, I did at the time. I guess. Yeah.
Again, that's right. We all have our opinions about politics and music and religion and whatever else. We all have our opinions. Your opinions are your opinions.
Yes.
And that's fine. So, I mean, do you still support the notion, maybe not as strongly now, but do you still support the notion of defunding the Minneapolis Police Department?
I guess my view on it is that, and I think it was then too, but that the police are asked to do too much.
Okay.
Way too much. And that other entities should take that burden off them. It's just, I think, the way things have developed over time.
Okay, fair enough. So, one last question that I think you had. Well, let me ask you a couple other questions. One question reads, because law enforcement officers have such dangerous jobs, it is not right to second-guess decisions they make while on duty. And you strongly disagreed with that.
Yeah. That's kind of a tricky worded question. Could you read it again?
Sure. Because law enforcement officers have such dangerous jobs, it is not right to second-guess decisions they make while they're on duty.
No, I stand by that.
Okay. Do you think that there's a difference between a decision that's made over a period of time versus a very rapid, quick decision?
I guess where I'm coming on from on that is that, you know, as government employees don't have any, I mean, every decision is going to be questioned, and that's how it should be.
Okay.
I mean,
So let me ask you the way I asked someone earlier today. about
Okay.
this. Okay. You have a police officer who is stealing drugs or money from the evidence department, right? They're on, while they're on duty. Is it okay to question that decision?
if they're stealing, yes.
Would it be okay if there were evidence to prosecute that police officer for doing that?
Yes, isn't that what yeah?
Now, take a different situation. I'm a police officer and I'm chasing someone in the car, right? High-speed chase down the highway. Car crashes, the guy gets out and starts running down the dark alley. I'm chasing after him, and all of a sudden he turns around and he pulls his hand up towards me,
Yeah.
right? And I shoot that person,
Yes.
right? Is there a different analysis in that situation than the former?
Yeah, I'm having a hard time following how they're similar.
Well, they're decisions that officers make in the line of
Oh,
duty.
the
Should they be
factor
second?
decisions?
Right. And should they be second guessed?
Yeah. Yes, they should be. I mean, I don't know. Second guessed is the wording I'd use.
Okay.
But questioned.
Question?
And I think 999 times out of 1,000, the second thing you said, where someone pulls out or even points their finger at that police officer made the decision they had to make, and that's fine, but it still can be questioned.
Okay. And that's fair enough. Again, I'm not.
You don't have. Yeah, I don't feel you have any expectation of just having no decision made on anything you do.
Okay, fair enough.
Particularly if you're a government employee.
Okay. What is the distinction between a government employee and a private employee?
There's more responsibility.
Okay.
For a government employee.
Okay. One of the statements is, I do not trust the police. And you circled strongly disagree. So you trust the police?
I do. I do.
You were asked a series of questions about both the Black Lives Matter.
Could I go back to that for a second?
Of course.
I do trust the police, but part of the reason I trust the police is because I know they're checks. They're checks to what they do, and I trust those checks. I trust. I have faith in the system.
Okay. And there are some other questions about that I'm going to ask you because.
Okay.
Okay. And I really appreciate that.
Okay.
So you were asked a couple of questions about the Black Lives Matter, whether it's movement or organization or one or the other, as well as Blue Lives Matter, organization and or movement, right?
Right. Yeah, okay.
And you have a very favorable view of the Black Lives Matter, and you write that it carries on the tradition of civil rights activists of the past and their struggle.
That's my perception, yeah.
And you continue to hold that belief?
I do. I'm ashamed to say I don't know enough about it, though.
Okay.
I'm not yeah, I'm not involved in it.
And with respect to Blue Lives Matter, you had a somewhat unfavorable opinion of them, and you wrote, I don't understand how anyone could view the police, Blue Lives, as somehow threatened or endangered when they are well armed and have all the power in most situations. I'm baffled by it.
Yeah, I'd say suspicious of it. I guess I just, yeah.
Okay.
I just didn't compute for me.
Okay. You have a background in history.
Yeah, I do.
Okay. I think you're.
That might be overstating it.
Oh, you have a degree in history?
Yeah.
Okay. You have a lawyer in your family who actually lives, like you share a duplex or something with her?
Yeah, that's my relative, my wife, yeah.
Okay. She no longer practices law?
No.
Okay. Would you, if you were to serve as a juror in this case, would you knock on the door and ask to talk about the law with her?
I wish I could.
Okay.
I came so close to telling her. I just stopped myself as I read that last sentence or whatever. Yeah. I'd love to talk to her about it, but
yeah,
I'm not going to.
Your father was a physician, right?
Yes.
And your wife is a nurse?
Yes.
Okay. So if there were to be medical evidence presented in this case, would you, I don't know, I may put my foot in my mouth, but is your father still alive?
No, he passed away.
Oh, I'm sorry. So with your wife, if there's medical evidence and you're trying to think, I don't understand how this works, would you go home at night and ask her about?
It would be tempting, but I don't think I would, no.
Okay. Can you promise us you won't?
I can promise you I won't. Yeah, it would.
So I've got just a few more questions for you, sir, and I really appreciate, again, your time. The last couple of questions I have are on your opinions regarding the justice system generally, and you were asked a question, do you believe that the jury system in this country is fair? Why or why not? And you write, although no system is infallible, when it comes to making a judgment as consequential as denying someone his or her freedom, I believe that being tried before 12 of your peers provides a fairness that wouldn't be there without a jury.
Yeah.
Good answer.
I amazed myself.
Explain, like, what's the difference between no jury and a jury? Like, why do you see that as such a benefit?
I have to admit I'm weak on the law. I'm weak on this subject. So, and even since I wrote that, I've learned more about. I don't think I even knew it had to be unanimous when I wrote that. Or I mean, I've kind of picking up things about. So, what's your question again?
I just was wondering, what do you think the benefit of having a jury
over just having the judge decide?
Right.
Yeah, I don't want to put down judges. It's just that independence from the government, from just this independent entity,
right,
that doesn't belong to the police department or to the county. It's an independent. I think that's
fair enough.
What I'd say.
Okay. So, again, I want to read to you two of your responses again, and then kind of circle back on some stuff. So, again, it asks, the question was, Under our system of justice, defendants are presumed innocent of the criminal charges against them.
Yeah.
Would you have difficulty following this principle of law? And your response again was, in a case with as much publicity as this case, it is difficult.
Yeah.
Based upon the visual evidence I have seen,
Yeah.
I haven't presumed the defendant
No.
is innocent.
Right.
But I know I have only seen and read a small fraction of what occurred. Knowing this, I believe I can presume innocence until all facts are presented to the jury. Okay? So I want you to think about that. I'm going to read you another one of your responses.
Okay.
The question was, do you want to serve as a juror in this case? And you said yes.
Yes.
And you said, it asks, why do you feel that way about serving as a juror in this case? And you wrote, I am marking yes because I want to look in the mirror every morning and know the person looking back at me wasn't afraid to do the right thing when called upon.
That's right.
I believe I would make a good juror for many reasons, but I will leave it up to others. And you kind of go on from there. A little. I mean, not much. I can read the rest if you want.
No.
Okay.
No, go this way.
So it strikes me, sir, that you have taken your obligation as a potential juror remarkably seriously. I'm telling
Thank
you that. And I think you've reflected, right? So you've acknowledged that once you saw the bystander video,
Right.
you did not presume Mr. Chauvin innocent, right?
No.
And-
I mean, I was, yeah.
Right? So you didn't presume him innocent. And also you have some very strongly held opinions, which again, it's your right to have those opinions. And I may agree or disagree with some of them.
Yeah.
The point being is that in view of your personal beliefs, right? You've acknowledged that you didn't presume Mr. Chauvin innocent, and you have concern about doing the right thing when called upon. Are you the right? Can you honestly say to us, I can put all of these things aside. I can follow the law. I can listen to the evidence. I can apply the evidence to the law and make a decision. Can you do that? Free from all of your other opinions.
Yeah. That last question about was the most difficult one. And I've thought about it a lot, and you know, I don't aspire to be on the jury. That was not it's not a goal or a dream of mine. But I wanted to, what I want to say, I know this isn't answering your last question, but it's my willingness to do it shouldn't be a factor in deciding if I'm willing to do. I'm totally willing to. So that's get into that, but that's not the important part. The important part is, do I think I could do it? And I do think I can do it.
Okay. So thinking you can do it and knowing you can do it are two different things.
You're right.
Right?
You're right. You know, that's true.
So if you're sitting here and you're listening to the evidence, right? And you've already had your opinion influenced by what you've seen in the past. Do you think it may affect your opinions about all of these things we've talked about? May harm my client because you're focusing on your opinion about police reform or defunding the police. Will you look at the evidence as a blank slate?
No, I respect that. I respect your. I take this very seriously, and I Yeah. I really think the answer is yes, I could. If you do your job well and you show me evidence, I definitely, that thing is when yeah.
But I don't have to show you evidence.
Oh, or not you, whatever. If I see evidence, I'm sorry. But yeah.
Your problem is seeing that video, right? I mean, you formed such a strong opinion based on that video that it is really cascading through the rest of your answers.
I think that anyone who saw that video had a reaction, right?
And I know we all want to be fair, right? We want to say that we're going to be a good juror, but again, I don't,
No, that's right. You don't know.
And we need to be certain of it.
Absolutely. Absolutely.
So I'll just ask you one last time. Can you?
I can, even though it pains me to say, I can.
Fair enough. If I may have a moment, Your Honor. Just one additional question. Sure. All right. So, sir, if you were to ultimately find a not guilty verdict, right, how do you think that would affect, well, how do I phrase this? Your wife and you share some views, right? Could you go home after finding a not guilty verdict, and how could you explain that to your wife?
I absolutely could, yeah.
You could?
Yes.
Okay.
Yes.
All right. No further questions. We'll exercise a peremptory, Your Honor.
Your Honor? Let me talk briefly. Right. Juror 39, we're going to excuse you from this case. And so the deputy will collect some of the material from you, and then you'll be released. You have no further jury service on this charge.
Okay.
Thank you.
And hold off bringing anybody else in. All right, we are outside the presence of the juror. The defense made a peremptory challenge. The state followed with a Batson challenge and stated, and maybe Mr. Schlischer, you can make a record of what your offer was, which I found was not a prima facie showing.
Thank you very much, Your Honor. The state did, as the court indicated, issue a Batson challenge to the defense's peremptory challenge of juror number 39. The articulated basis for the Batson challenge is that the prospective juror identifies as Hispanic. We believe that the prospective juror stated an unequivocal ability to follow the law, follow the court's instructions, presume innocence, and did not express any views that were outside of what other seated jurors have expressed.
All right, I would note, first of all, that you're telling the court the standard for a challenge for cause. This is not a challenge for cause. I don't find that this was race-based. This juror was very torn, you could tell, and he had difficulty coming to ultimately what I think Mr. Nelson was trying to get to was a challenge for cause, that he could not presume innocence. It was difficult for him to get there. It was difficult for him to get beyond the videotape because he likened it, unlike any other potential juror, to a World War II occupation force. His wife has engaged in went with protests. That does not by itself. He did not participate. So that's not a significant factor, but I can see why the close relationship with somebody who is deeply involved and his opinions regarding the defendant as expressed in the questionnaire give the defense a race-neutral reason for their strike, and I don't think the state has made a prima facie case. I would note for the record that we have 6 jurors so far. They identify as follows from the jury records. 1 is multiracial, 3 are white, 1 is Hispanic, and 1 is black. So I see no pattern whatsoever from the defense of striking racial minorities. So I don't think that supports the state's challenge either. So that's the court's ruling. We'll bring in the next juror. Thank you. Jury number 40. Okay, come on up. And you are juror number 40, is that correct?
I am.
All right. A couple things before I turn you over to the attorneys for questioning. First of all, I'm going to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. First thing I'm going to do is ask you about the questionnaire. You filled out a questionnaire. Thank you for taking the time to do that. Is there anything as you sit here right now, since it's been several months, that you think you would change or add to, or even some opinions that you might change because perhaps your opinion has evolved over the last few months?
I don't think so, although I was kind of trying to remember the questionnaire and my answers, and so
Okay.
it's been a while.
I'm going to ask you to pull up just a little bit.
Sorry. Okay.
And also, we are exercising COVID precautions. I'm going to keep my mask on. We have plexiglass between us, and you also have plexiglass between you and the attorneys. So I do allow in this circumstance, if you would like, to take off your mask, but I leave it to you. Sometimes the mask makes it a little harder to understand people, but I leave it to your discretion as far as keeping it on or off.
Okay.
Any changes or additions to the questionnaire that you're aware of?
Not that I can think of, no.
And again, it's been a long time. The attorneys might point to specific answers you gave, because I assume you didn't keep a copy of your questionnaire.
I did not. Yeah.
So to refresh your memory, they may go to a question and read it over, including your answer. If your answer today is different, don't worry about it. What we want more than anything is your honest, candid answers to the questions.
Okay.
Also, the questionnaire advises you not to read any articles or pay attention to any media. But we realize that in the months since then, inadvertently you may have come across some information. You see a headline, or a friend talks to you about the case, and we told you don't tell anybody you're a juror, so you can't exactly stop them. Anything like that happened to you that added to your knowledge of the case?
I would say not that added to my knowledge, no.
Okay, anything about the facts of the case, or the participants, or pretrial matters that have been litigated, anything like that?
No.
Okay. The whole point of this is there's a variety of things that you know about the case, and you may have formed certain opinions about the case. And we want to make sure that if you sit as a juror, you decide this case only on the evidence and on the law that I give you, and that you put aside anything you know about the case, put aside any opinions about the case, and just take the evidence as it comes. Do you think you could do that?
I do.
Okay. You were given a long list of witnesses. Did you recognize anybody on the list?
There's one name, kind of a common name. So David Elm might have been I think it was a student maybe years ago.
Okay. I'm not sure that person's participation in the case, but if that person appears, how long ago was this person a student?
10 years ago.
Okay.
Yeah.
Whatever their occupation is, or whatever their role in this case, do you think that would affect your ability to weigh them dispassionately and neutrally?
No, because I really don't. I recognize the name, but I don't really remember the person very much.
Okay, and so you could treat them like any other witness as far as weighing their credibility?
Absolutely.
Okay. We've also had an estimate of the trial length would be, if you were on this jury, we would excuse you and you could go about your business until March 29th, and then come back. We would start trial. We anticipate 4 weeks. And I think you may have indicated some concern with the length of the trial.
So as a teacher, I'm concerned about my students, but I have made arrangements for substitutes as needed. So.
Okay, so you could make it work?
Yes.
Okay. Do you have any questions for me before I turn you over to the attorneys?
Not that I can think of.
All right, with that, regarding juror number 40, Mr. Nelson, you may inquire.
Good afternoon, sir.
Good afternoon.
So that microphone unfortunately doesn't pull closer to you, so I think you got to move in.
All right.
And with your mask on, it's fine to keep it on, but obviously makes it a little bit more difficult to hear. Excuse me. So what I'm going to do, sir, is I'm going to ask you a series of some kind of general questions first.
Okay.
And then from there, I'd like to ask you some specific questions about some answers in your questionnaire. Okay?
Okay.
Now, I know it was a long time ago, and you probably haven't read it. You didn't keep a copy.
Right.
Nobody's trying to trick you. We'll read it to you, refresh your recollection a little, okay?
Okay.
All right. So first question I have is, if you and I were to meet in some social circumstance, whether it be a party or an event of some sort, what are a few things that you would want me to know, or what are a few things I would learn about you in that conversation?
I'm a husband and dad. I'm a teacher. I love singing in my church choir with my wife. A musician.
Okay. Are you a musician in ways other than with your voice? Do you play instruments?
I don't play instruments. I'm a singer and a music teacher.
Okay, perfect. And it's my understanding of the process that at some point you received a letter in the mail that said you were going to be summoned for jury duty. That was the first sort of notification, right?
Yes.
When you received that first notification, what was your first reaction?
Oh my.
Okay. Why?
Well, I mean, I know that it's a case that it's a large magnitude, and it's honestly a little nerve-wracking.
Okay.
But I gave it some thought and recognized that it's my duty to try to serve jury duty as needed.
Okay. And so you had that thought when you learned that it was this particular case, right? Because is that when you learned it was this particular case when you got this big questionnaire in the mail?
I think that's what, yeah, it was a questionnaire, right?
Right. Okay. And how did you feel today when you got here to the Government Center?
A little nervous. I can stand up and sing in front of a group of people and be comfortable, but talking in front of people and stuff is nerve-wracking.
Sure. Fair enough. I assure you I don't want to trade roles with you. I don't think you'd appreciate that. But the security and the fortifications, you said that made you kind of nervous, or just being in this room, I guess?
No, the process more, actually the security made me, that felt good.
Okay.
Yeah.
So because I know you've expressed some concerns about anonymity and things of that nature in your questionnaire, and so you were concerned about it, and seeing those preparations made you feel safe.
That's correct.
Okay. And then ultimately, this afternoon, when the judge kind of gave us the instructions, or gave you the instructions about how we're doing everything we can to maintain your anonymity at this point, how did that make you feel?
I mean, good. I still have a little bit of concern about, after the trial, if when our names are released.
Okay.
I know sometimes they're not. I don't know how that works, but.
Okay. So at some point they may be, though, too, right?
Right.
We don't know what the future will hold, but at some point they may be. Why does that make you nervous?
I mean, it can potentially draw some unwanted attention. I don't know.
Okay. Are you thinking more in terms of harassment or potential harassment, or are you thinking more in terms of physical safety, like violence that could be visited upon you?
I guess I'm just thinking in terms of people wanting information and that kind of thing.
Okay. So no concerns for your physical safety, just more concerns you just kind of want to be anonymous.
Yeah, I would say my wife has more concerns about physical
okay.
safeties, but yeah.
So, and perfectly natural, you've talked about this with your wife, right?
Yes.
And you said she has some more concerns about your physical safety?
Yeah.
Do you think that's justified on her part?
I mean, I've tried to convince her that I don't think that that's a probability or an issue. But,
okay. Yeah. Have you been successful in your convincing?
I guess that's fine. I was going to say the jury's still out, but
okay. Well, let me ask you just some kind of other general questions. Can you think of a situation in your life where you have been called upon to resolve a dispute between two people?
Sure.
Okay. Now, just thinking about that in your mind, without any real details, how did you approach that situation, and what did you do to try to resolve that dispute?
I'm thinking of some students, and so brought them together and actually first heard kind of each of their stories from their own perspective, and then brought them together and encouraged them to talk it through and work it out.
Okay. In terms of being a juror, right? I mean, this is in some regard part of what your job would be as you analyze the evidence in the case. Disputes may arise, right? In the jury room, a piece of evidence made to one juror seem to be very important and not to another, right?
Sure.
So in that jury room, there may be disputes. And ultimately, that's what this case is about too, right? It's a dispute. There's two different perspectives or two sides of the story. So what tools would you bring as a juror in those two scenarios, both in terms of resolving disputes among jurors as well as analyzing the evidence? And that's a really long, complicated question, and I'm sorry.
I guess I have a pretty calm demeanor and can try to encourage people to listen to each other and try to explain their points of view to the best extent possible.
Okay. Do you think that there are things in terms of the analysis of the evidence? How would you resolve a dispute over evidence? Right, like if
I guess I haven't thought about it. I'm not sure.
Okay. Well, let me try to give you a simple hypothetical. Say that there is some piece of evidence, and we'll just pick a number, a lab report, right? And you're looking at this lab report and you're saying, I think that this is a really important piece of information. But somebody else goes, that's nonsense. We don't need to worry about that, right? How do you, something that's important to you is not important to someone else. How do you resolve that?
Kind of make a list of pros and cons as to why it's valuable and why it seems important.
Okay. And in terms of, you understand that a jury decision in this type of a case has to be unanimous?
Mm-hmm.
That's a yes?
Yes.
Okay. And that means all 12 people have to agree.
Right.
Right? So if you're looking at this piece of evidence, right, and the majority of the group is saying, ignore it, quit, it's not important, are you the type of person that would just simply kind of follow along with everyone else? Or would you say, no, this is really important and you need to hear me and speak your mind?
Probably the latter.
Okay. You're going to hear my opinion type of a guy?
Yeah, yes.
Okay. Now, can you think of a situation in your personal life where you've had to decide between two stories which person is telling the truth about a story?
I'm not coming up with anything specifically right now.
Sure. You have some grown children, right?
Yes.
And at some point in their adolescence or young adulthood, perhaps your children had two very different stories about something that happened.
Actually, I can't think of any circumstances like that.
All right. Well,
it might be my perspective might have been different than theirs.
Okay. Well, let's just kind of take it in the hypothetical then. How do you tell if someone is telling the truth?
You listen to what they're saying, you pay attention to how they're saying it. If there's other people that corroborate. That all comes into play.
Okay. So now let's take it in a little broader lens. What if two witnesses are looking at that same that same incident, right? That same thing. They're watching it happen. They're standing right next to each other. And one of them says, this is what happened. And the other says, this is what happened, right? And they're nowhere close to each other. How do you reconcile it? Same process or?
Yeah, I mean, I think they just have to kind of keep trying to find new ways to express what they're seeing and see if they can come to some sort of understanding that they can both agree upon.
Okay. Can you think of a circumstance in your life, either personally or professionally, where you were 100% convinced of something and it later turned out you were wrong?
I'm sure that's happened.
Okay. Are you the type of person who can reflect back and say, I made a mistake and I'm going to learn from it? Or are you kind of the person that brushes it aside and...
Oh, no, definitely. I've learned a lot from mistakes.
Okay, great. So I'm going to ask you a series of questions about your responses. And again, I'll read you what you wrote. So no tricks afoot here, okay? The first question that you're asked in the questionnaire is what you remember seeing about this incident in either the media or in conversation, your general knowledge about this particular case, okay? Now, before I go down this path, I want to make sure that we're all on the same page. A video, you may describe this video, was taken by a bystander. That video was uploaded to a social media platform, went viral, and became news, right?
Yes.
Have you seen that video?
Yes.
Okay. And I think you said you've seen it 6 or more times.
I'm guessing that's about right, yeah.
Okay. And I guess my question is in that 6 or more times, when you learned of this video, did you go onto a social media platform or some other website and watch the video from start to finish, or are you referring to smaller clips and segments?
I mean, the first few times, I think it was just the smaller clips, and then there was one time where I saw a longer segment.
Okay. Like, have you seen any other videos of this incident that have been made publicly available?
I feel like there was one that was like from a different angle. Yeah.
Okay. Do you remember
I don't remember much about it.
Do you remember seeing any like body cameras from police officers or security footage or anything of that nature?
I'm sorry, that's what I'm not sure of what the other angle was. Yeah.
Okay, that's fair enough. But so this longer video that you watched, you watched that more than 6 times, or was that just once?
No, just once. Yeah.
Okay. And so I'm going to ask you, you wrote kind of a long, you tried to remember everything that you had heard about this case, and you had a lot more than just this incident, right, about the people involved and all of that. So are you a fairly regular consumer of the news?
Yeah.
By television, newspaper?
So NPR, and we get the newspaper and we watch the news pretty regularly, yeah.
Okay. So you wrote a little bit about the charges initially, or what you recalled to be the charges, right? And then you recall reading some article that Mr. Floyd and Mr. Chauvin had worked together in some location, right? And you also heard that Mr. Floyd didn't want to get into the squad car because he was claustrophobic.
Right.
Right. You also recall hearing something about conflicting autopsy reports as to whether Floyd had drugs in his system?
Well, I don't know if it was about that or if it was just kind of different conclusions, and I don't remember exactly what those were. But.
Okay. And then you recall reading some information about Mr. Chauvin's personal, like divorce and
right.
some other things he has going on, right?
Yes.
So you have, and you're probably one of the few people that kind of went beyond just this incident last year in May, right? And I just kind of wanted to ask you some questions about that. Do you understand that in this trial, evidence will be presented in this courtroom, right?
Yes.
And some of the things that you reference in here, obviously you've heard about them, you've read about these things, that may not be evidence in this case.
Yeah, I understand.
Okay. Can you set those things that you've heard in the news aside and judge the case on the evidence in the courtroom?
Yeah, because you always have to kind of take it with a grain of salt.
Right. What do you mean? What do you mean take it with a grain of salt? What do you have to take?
Well, I mean, when there's ongoing investigations and information coming forth, as information comes out, later it may not be accurate. And
okay. The question asked you, from what you have seen, read, or heard, do you have a general impression of the defendant? To which your response, or what you chose, was very negative. And when asked, why do you feel that way, you wrote, seeing the look on Chauvin's face in the video and seeing the other officers and him ignoring pleas of bystanders to stop once he was on the ground and subdued.
Yeah, that was difficult.
Okay. Why was that difficult?
When you see somebody who is already subdued, it seemed very unnecessary and over the top to me.
Okay. You mentioned kind of earlier in terms of dispute resolution is the importance of hearing both sides, right?
Yeah.
Would you agree that there's probably more information that will come out in this courtroom that you've not learned?
Oh, of course.
And some of that information will be relevant to perhaps police training or other aspects of law enforcement that may change. Would you be willing to allow that information to change your initial perception?
Yeah. I mean, if that potentially, sure.
Okay. Well, you understand, again, Mr. Chauvin is presumed innocent of these charges.
Yep.
And you formed and it's you're not the first person to come in here and have a negative opinion of the case, right? So again, it's perfectly acceptable. They're your views and you're entitled to hold your views. The question is, can you set aside your views and judge this case on the evidence and the law as it's presented in court?
Yes, I think I can.
Right? So you think you can or you can? There's a difference.
Yes, I can.
Okay. You had the question was asked of you of your impression of Mr. Floyd. You checked it was neutral, and you said, I don't know much about him besides what I saw in the video. I understand he has a record and he may have tried to buy something at Cup Foods with possibly a fake bill, but he shouldn't have been treated that way for that, right?
Yeah.
So again, can you at least acknowledge that you formed your impression about Mr. Floyd is certainly in response to how you viewed he was treated by the Minneapolis police officers?
Based on what I saw in the video and such, yeah.
Okay. You were asked if you've talked about Mr. Floyd's death with your family, friends, or coworkers, or discussed it online, for example, on social media, and you checked yes. And it was asked, if yes, what opinions have you expressed? You wrote, Floyd had a record but didn't deserve to die by die from this by a cop who is supposed to serve and protect, who ignored his pleas that he couldn't breathe. Chauvin should have stopped. The other officers should have intervened, as I think one tried. And maybe it goes on. That was the end.
As I think, what was the last part?
I think one tried.
Oh, right.
Okay. So, I guess again, you have formed a very strong opinion. Agreed?
Yeah.
Right? You've expressed it kind of in three different ways in response to three different questions. Right?
Mm-hmm.
I'm sorry,
Yes,
is that a
sorry.
yes? That's okay. And are you convinced that you can set aside your very strong opinions, presume Mr. Chauvin innocent, and analyze this case on the facts and evidence as presented in court?
Yes, because I think you have to approach it with a blank slate and start all over.
So you were asked a question about the protests that occurred after the death of Mr. Floyd. You wrote that the protests solidified people around the need for change in our police and our society's systemic racism. The vandalism by Boogaloo Boys and others was very distressing.
Yes.
Okay. And you underlined the word need in your sentence, solidified people around the need for change in our police.
Yes.
So you have an opinion about Mr. Chauvin, right? Again, nothing wrong with that. Right? And you also have a pretty strong opinion that there needs to be change or police reform.
Yes, I mean, I think that's even been noted by the head of the police.
Okay.
Mr. Nelson, I think we're going to take our afternoon break. We've been
Okay.
So, sir, I'm going to ask you to go back to the courtroom. Deputy will direct you. We'll be on break until 3:30. Thank you.
Well, before he comes back in, we're not on the record, but you'll notice I kept the advisory the same as far as.
I hope you don't mind that we take the breaks. I've been pushing these folks since 8 a.m. this morning, so
That's understandable.
I'm going to turn it back over to Mr. Nelson.
Okay.
Welcome back, sir. Thank you.
Mm-hmm.
So, we were talking about some of the opinions and things that you held, and I have a question for you. It asks, did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death? And you checked yes, and then there's not any information. Did you personally participate?
I did not.
Okay. But you did visit the site of 38th in Chicago?
I did.
Okay. And in fact, you posted about that on social media, correct?
I don't recall. I probably did.
Okay. Would it surprise you to learn that we're looking into the background of our potential jurors? And that I looked at your social media?
Okay.
You wrote that you went to the site of the George Floyd Memorial at 38th in Chicago where he was murdered. There was a mix of all sorts of people. They were people providing food and supplies for those in need, people crying, people sharing, hugging, laughing with each other. Holy ground. There was a time for prayer that lasted 9 minutes. Most knelt for that. 9 minutes is a long time. There is a groundswell for change. It was peaceful and beautiful and moving. Right?
I'm glad I wrote that.
Okay. And again, you are entitled to your opinions, right?
Yeah.
And some opinions, right, they're a little more flexible than others, right? Would you agree with that general concept?
Sure.
And other opinions are very, very, very entrenched in our lives, right?
Yes.
Okay. And those opinions can affect our decisions. Would you agree with that?
Yes.
Okay. So whether you have a opinion, you would expect your opinions to sometimes guide your actions, would you not?
Right.
If you hold a particular religious belief, or you hold a particular philosophical belief, or even if it's simply my favorite music is X, right?
Right.
You turn on the radio and you listen to the music, your opinions guide what you do. You would agree with that?
Sure. Yep.
But this is a case of tremendous importance. You've said that.
Yep.
And my concern is that you're telling us that you can set aside your opinions and you can judge this case only on the evidence presented in court.
Yeah, I mean, I think it's a matter of recognizing the situation that I'm in as a potential juror and the responsibility to, like I said, clean the slate and start fresh from what's presented in here.
Okay. If you felt, after all of the evidence was presented in this case, that the state had failed to meet its burden of proof beyond a reasonable doubt, would you have any hesitation in finding Mr. Chauvin not guilty?
I don't think so.
Okay. Again, it needs to be unequivocal, excuse me. Could you?
Yeah, I can imagine that, yes.
Would you then post about that on social media?
I don't know. I've kind of decided that I'm refraining from any of that kind of posting right now. I'm posting music that I like and that kind of thing.
Right. But I mean, you posted and you have an opinion that 38th in Chicago is sacred ground or holy ground. I don't remember what you used. Right? Would you be able to proudly say to your friends and Facebook followers and family members, I was a juror who found Mr. Chauvin not guilty?
Objection.
I guess I can imagine that possibility. That's probably best I can answer that.
Okay, fair enough. Your Honor, we'll exercise a peremptory.
All right. Thank you, sir. You're going to be excused from this jury. That'll also complete your jury service for this term, so you don't have to report back to anybody. Okay. But you can gather your things. The deputy will take some paperwork from you, and then we'll just wish you a good day.
All right.
Thank you. I have that as defense 7.
One the thing I was trying to say is when I gave the group advisory, I kept the description of the charges exactly the same, even knowing that we've added murder 3 back. That will become evident when we open and talk about the charges, but I want every group of jurors to have the same instructions before trial, so that's the reason for that.
Okay. Okay, come on up, right here. Perfect. Good afternoon. You are juror number 41, is that correct?
Yes.
All right. Before I turn the questioning over to the attorneys, a few things we have to go over. First of all, I'm going to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I swear.
Okay, thank you. We are exercising COVID precautions, but I'm going to keep my mask on. We have plexiglass between us, and you'll have plexiglass between you and the attorneys who also have their own plexiglass. The upshot of that means if you'd like, or if you think you could be heard better, you can take the mask off while you're being examined. And if you do so, I would ask in either case that you pull up to the microphone so we can hear you nice and loud. All right? Now, to begin with, you filled out a questionnaire, and thank you for taking the time to do that. That was greatly appreciated. Was everything true that you put on that questionnaire?
Yes, it's been a while since I have filled it out, but I believe everything is true. There is one question that I am thinking about a lot in my brain, and I'm not sure, I can't remember exactly how I answered it before, but.
Okay. And you anticipated my next question, which was, are any changes or additions that you can think of right now?
Yeah, I think the one thing that is kind of instilled in my brain is the question regarding impartiality. I do feel that after thinking about it more deeply, that I'm not sure that I can bring impartiality to this case at this point.
Okay, tell me a little bit about that. Why you feel that way?
Yeah, I have seen the video, and I do feel like this case is unique, and that if it was any other case, I could probably absolutely be impartial. But having seen the video, I do feel pretty strongly about it being a high level of evidence in this case, and I do feel that I have formed an opinion on the matter, and I think over the last 9 months, it's sort of been ingrained in my brain. So I think that it would be hard to get rid of that opinion, and I'm really not sure if I could.
Okay. I'm not pushing back against that opinion. I'm just going to test it a little bit.
Sure.
Pretty much everybody who's come in has some information about the case. Some have seen the video. Great many have seen the video. Mm-hmm. Some have just seen the still images. Others may have read articles. A variety of exposure to what this case is about. And acknowledging that, we have not asked people, are you ignorant of the case? It's more, you've read about it, you know about it, you may have even formed opinions about it. Knowing yourself, can you put those aside? Because to be a juror, you have to be fair and impartial, which means blank slate. You can have opinions, not a problem. But you have to put those aside, and you have to put aside what you know about the case from outside the courtroom. And I think you've been very honest, and I'm glad you've reflected on this, because the question is, you, knowing yourself, do you really think you could be fair and impartial or not?
Yes, I think I understand where you're getting at, and I think that I think still think this case is unique. I think me as a person would be great on any other case, but the death has actually impacted my life as I've thought about it more, and in fact, I have volunteered for a nonprofit organization to help serve underserved and vulnerable children as a result of the societal impact and everything. So I do feel like it has impacted me in that I think change needs to happen, and that's kind of where my heart is.
Okay. And so the answer to the basic question, can you be fair and impartial in this case? Your answer is?
No.
All right. I'm just going to ask if any of the attorneys wish to inquire. Mr. Nelson?
No, thank you.
Mr. Slisher? If you would.
All right, juror number 41, good afternoon. And it's not my intent to try to talk you out of anything, but I just want to make sure, because this is a unique matter and it's so important. And so I just want to make sure that I'm clear. Now, I understand that you've viewed the video, right? And that had an effect on you.
Yes.
And sounds like you have a pretty good idea of what happened based on the video.
Yes.
Factually. But there are two parts to this, right? There's what happened, and then there's what that means, okay? And so you may have reviewed some video that could potentially be evidence in the case, and that's fine. The question is, if the judge gave you a set of instructions that said, these are the elements of the charge, right? This is what he's charged with, and here's how the government has to prove it. Would you be able to follow the judge's instructions? And even if the facts were as you believe them to be, you discover that the law does not support the charges, would you be able to enter a verdict of not guilty? Or are your feelings about the case such that even if the facts don't support a conviction, you would still want to convict?
I'm trying to think about how to answer that. Yeah, I do still feel that my feelings, I'm not sure that I can put my feelings aside. After watching the video, I do feel that there are multiple time points in the video that things that could have gone differently. And it's really hard to, I'm not looking at it at the law, I guess, but I'm educated and I have an opinion that I do feel that things could have gone differently, and I don't think that I could change that.
Okay. And so it sounds like sitting here today, you know, as much as you'd like to, you don't think that you could give the defendant a fair trial.
Exactly. I wish I could, but I don't think I can.
Well, we really appreciate your honesty, and thank you very much. I appreciate your time today.
All right. First of all, let me thank you for your honesty. And the only thing a juror can do wrong is to not be honest. And I really appreciate it when jurors reflect on their own thoughts about whether they can truly be fair and impartial on a case. It's not a failure to say you can't in a specific case. It's just a recognition this is not the case for you. As I said at the beginning, being excused does not mean that you are not a fair and impartial person. It's just this case. So I'm going to excuse you. You are actually released from all your jury service, so you don't have to worry about reporting to anybody. We might send you a summons in a few years, but other than that, you are free to go. The deputy will collect some paperwork for you.
Okay.
All right. Thank you so much.
Thank you, Judge Cahill.
Yeah. We kicked loose our last year, didn't we? Well, there's Murphy's Law. We kicked loose our last year thinking that we would go till at least 4:30. So we've got 5 and 3 coming tomorrow. That is 5 in the morning. So the one we kicked loose today plus 4 in the morning, and then 3 more in the afternoon. So nevertheless, as I count it, we have 6 jurors. 7 peremptories for the defense, 4 for the state. Am I correct on that?
I have.
All right. Great. With that, and there are no motions tomorrow, we are in recess until 9 a.m. tomorrow. Sure.